Good morning, everybody. Happy Friday. And we have declared that Friday once again is Friday. Wednesday used to be the new Friday, but this week has been kind of hell. So Friday's Friday again. Let's have a great day. We'll start with Judge Glazer, Miami-Dade. Guy in a hospital bed. Let's see what's going on.
Por favor, comuníquese con las oficinas de los abogados de oficio tan pronto pueda, señor.
All right, who are the gentlemen sitting there?
This is Mr. Patrick, number 52 on page 21, I think it is. 21.
Who is it?
Forrest Patrick.
Patrick.
Forrest Patrick, okay. Hi, Mr. Patrick. You were arrested for aggravated battery. I will appoint the public defender's office for you. Sir, you are ordered to stay away from the alleged victim, Brian Perez. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. Do you understand the stay away order?
Yes, Your Honor.
All right, thank you. So he hit him with a pair of blue side cutters.
Pliers.
Okay, I'll find probable cause for aggravated battery. He's 80 years old. Today's, what's it called? Senior day at bond hearings. What do you live next door to him or no?
So, let's see.
He doesn't live in our project.
The victim was in the neighbor's driveway removing a boot from the neighbor's car, so I don't think the victim.
So it doesn't look like he's.
He has a few priors back from the 80s, but he's been in good behavior since then, really. One from. What do you want me to do? Is that okay with pretrial given his age? Yes.
Yes, please.
Sir, try and behave yourself. You get rearrested for anything else, you'll get locked up in jail. And I know you don't want to spend your golden years at the jail. Pretrial alternate bond, $5,000. Have a good day. Did I start on page 1 or do you have the one I passed? I passed the two. Mr. Hudak and Mr. Almeida. Who do you have for me?
They're not here yet, Your Honor.
All right. Marissa Franco, page 1.
Tap, just one count.
Your Honor, can we call Lázaro Hernandez,
Oh, yeah,
page 22, number 54?
Getting real upset. I don't mind calling anybody out of turn, but if you tell me beforehand, we're happy to pull the case. Bring him in. Is Mr. Lázaro Hernandez, page 22. Good morning, sir. You were arrested
Good morning.
for battery by a detainee on another detainee. I will appoint the public defender's office for you. There's probable cause for the charge. Your bond is $2,500. Have a nice day. You have the victim's name in there?
It's in there.
Can I start on page 1 or you got some others you want me to call? Have Miss Marissa, I'm sorry, it's Miss Marissa Franco, please.
Tap, one count.
She's awarded, Your Honor. We need to reset it.
Ward D, there's
Yeah.
probable cause, reset Ward D.
For one count, right, Judge?
Yeah. Then we have Bethany Gallahan, page 1. Hello, ma'am. Good morning. You were arrested for possession of cocaine. And 2 counts. I will appoint the public defender's office for you. Tap,
Same thing.
okay? 1
Yep.
count.
One count.
Tap alternate bond, $2,500, count 1. ROR, count 2. What's the reset date, please? Is it September 29th? Okay, you have to come to court for your arraignment on September 29th at 9 a.m., courtroom 6-2. Have a good day.
Judge, she's one of 8 people arrested on this case. Just so you-
I
We'll
understand.
deal with it.
Next is Eileen Ventura, page 1.
A co-defendant, she's got an address, so maybe pretrial?
Good morning, ma'am. You were arrested for possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you. There's probable cause for count 1. There's probable cause for, let me see, is it pipe? What am I looking for paraphernalia?
A
So,
pipe with residue, Judge.
yeah,
Pretrial services, alternate bond, $2,500, count 1, $500, count 2. Have a nice day. Next is Veronica C. on page 1.
Ms. Corey, I'll address this.
Good morning, ma'am. You were arrested for possession with intent to sell cocaine, possession with intent to sell crystal meth, possession with intent to sell crack cocaine, possession with intent to sell ecstasy, possession with intent to sell LSD. I will appoint the public defender's office for you. So what's
The
going on? It's a
judge.
search warrant?
Here's what's going on. It's a search warrant. There's people found on the patio. There's people who are leaving the house. There's drugs found in the house. She was found in the house, but the A form doesn't specifically say that the drugs were in plain view. I think maybe probable cause cocaine possession, give her a program. I don't know if Ms. Corey is willing to waive the issue.
Yes, that's fine.
All right, pretrial services, alternate bond, count 1 is $2,500. You want me to ROR counts 2 through 5?
Yes.
And then there's probable cause for
She's got
possession
an
of
address,
cocaine.
Rebecca? Ms. Corey, she's got an address?
No, we'll need the TAP program.
TAP alternate bond, $2,500, count 1, 2 through 5, ROR. Ma'am, you have to come to court for your arraignment on September 29th at 9 a.m. Courtroom 6-2, Judge Altfield. Have a nice day.
Your Honor, we need to do one out of turn. He's in a safety cell from Metro West, Manuel Vasquez, number 50, on page 20, please.
Thank you.
Thank you.
Manuel Vasquez, page 20. Let's
What if
bring it
Metro
up.
West is safety cell?
Metro West there. After that will
Thumbs
be
up, Your Honor.
Taylor Kosowski. Can you call Victor and let him know where we are, please? So he's not there. Let's call up who's here. Taylor
In right
Kosowski.
now, Your Honor.
What?
He's
Coming
here.
in right now.
English or Spanish? English.
Oh, this is Mr. Vasquez. Good morning, sir.
Good
You
morning,
were
Your Honor.
You were arrested for introduction of a controlled substance at the jail. It's called heroin. Sir, can you afford to hire a lawyer?
It was syrup, Your Honor. I would like
I'll
to
appoint
make
the public defender's office for you. Now, there's probable cause for the charge of,
Judge, he indicates he has Marlene Montaner as his attorney.
okay, she's not here. Did you call her and tell her you got arrested?
I can't make an outgoing phone call because I'm in confinement. I would like to make a brief statement for the record, Your Honor. 30.
I don't want to hear it. How about that? Don't talk, Miss Montaner would tell you, don't say anything. You're presumed not guilty. I don't know where it says a brown liquid. Where does it say it's heroin?
It said that the contents tested positive for heroin.
For heroin, I got it, I see it. There's probable cause. I'm appointing the public defender's office for you. If Ms. Montaner wants to file an appearance, she can substitute. Setting a bond at $2,500. Have a nice day. Next, we have Taylor Kosowski, page 2.
Well, Well, the next contestant comes up. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Friday. We have restored Friday to being Friday, so again, let's have a great day. We're going to ride with Judge Glazer here for a while. Number one, because she's in a mood, and that's always entertaining. Number two, it's kind of a slow roll this morning. There's a lot of landlord-tenant, which we try to avoid. There's a couple other things going on, which I've got my eyes on, including Judge Stevens, who, at least for the time being, I'm going to relabel as Judge Disappointment. But for now, we'll stick with Judge Glazer.
A lot of charges: selling cocaine, MDMA, ecstasy, and LSD. Public Defender's Office is appointed for you. You want to stipulate one count of possession of cocaine and
Yeah,
Should get a
yes, Judge,
program-
she does have an address, so a pretrial would be acceptable.
count one, there's probable cause for possession of cocaine. Pretrial services, alternate bond, $2,500, count 1, 2 through 5 would be an ROR each count. Have a nice day. Next we have is Isis Caldavia, page 2. Good morning, ma'am. You were arrested for possession of cocaine and 2 counts. I will appoint the public defender's office for you. There's probable cause. What do you want? You have a place to stay, ma'am?
Yes. Judge,
Pretrial services, alternate bond, 2,500, count 1, ROR, count 2. Have a nice day. Then we have Kelly Brito, page 3.
No school enhancements.
My goodness, we have a big calendar today. What is it, 20-something pages? 23. Good morning, Miss Brito. You were arrested for possession of cocaine within 1,000 feet of a school and possession of drug paraphernalia. Public Defender's Office is appointed for you. There's probable cause on count 1 for possession of cocaine. It's TAP alternate bond, 2,500, count 1, $500, count 2. You have to go to court.
Did she indicate she has a place to stay?
Well,
That would be confirmable?
it's not here. It's not listed. It says homeless, so I'm doing TAP. TAP, because she may get stuck there otherwise if she doesn't. The arraignment date is September 29th at 9 a.m., courtroom 27. Have a nice day. Next is Ira Knowles.
Your Honor, after this defendant, we have Mr. Contreras.
Okay. Hi, Mr. Knowles. You were arrested for burglary, possession of burglary tools, loitering or prowling, and obstruction by a disguised person. I will appoint the public defender's office for you. Sir, you are ordered to stay away from the racetrack gas station at 12800 Southwest 152nd Street in Miami, Florida. You are not allowed to go to that location. You must stay away from there.
So it's false name after arrest on count 3.
Okay, I see that.
And on count 1, Judge, there's no burglary and there's nothing this tool was.
Well,
Yes, they say it's used to shatter glass. I think there is
And he's trying to
probable
get
There's
cause.
nothing indicating he was trying to shatter a glass in any way, Judge.
he's
so
trying to break into cars.
They're not saying he used this object
I think
to
there's PC.
utilize it for any sort of burglary, Judge.
I disagree. It shows he attempted to do a burglary and he had the tool on him, so I believe that's sufficient. I'm setting up on count 1, possession of burglary tools is $2,500. Count 2, loitering or prowling is $150. Count 3, was it false name after arrest, is $500. Have a good day.
Judge, would you consider any program for Mr. Knowles?
State, you have an objection to a
Yes, he's
program to
lying to
tap?
the police about his name. He's trying to break into cars. And he also has prior felony convictions.
Judge, it's not a violent offense.
This doesn't have anything recent.
He did, it looks like some jail time last year.
Where? Here? Oh, it's for fleeing. It's not
He
for
didn't
breaking
damage
into
the
cars.
car.
That's fine. I'll give him TAP alternate bond, 2,500 count 1, 150 count 2, 500 count 3. You have to come to court for your arraignment on September 29th at 9 a.m., Courtroom 7-2, Judge Milian.
It is over state's objection.
Okay, thank you. Let me call up Mr. Contreras. Is that his name who you have, Mr. Alexander? Okay, thank you.
He has 2 ACs, no bond.
Thank you. Good morning. Good morning, Mr. Contreras Vega. Do you speak English?
Yes, Judge.
So you were arrested for petty theft, 2 or more convictions from May 15th of 2025. I will appoint the public defender's office for you. You're also out on felony bond hold for F-24 26619, I believe, and F-24 26618. So it's 2 counts of petty theft, 2 or more convictions. You are ordered to stay away from the CVS store at 888 Biscayne Boulevard in Miami, Florida. You are not allowed to go to that store and you must stay away from there. What do you want to say, sir?
Devin Alexander, victim representative for CVS for the record, Your Honor. Your Honor, we would just ask for a higher than standard bond. Over the 2 events, I think 5:15 and 6:30, he hit for $300. But in the way that he did it, it was very brazen. He was followed by a team member requesting him to put back the items and to leave the store both times. And he didn't, obviously, and walked out, and he has no regard for any rules or requests that the store gives him. So we would just ask for a higher than standard bond and a stay away order, and defer to the court as to the specific amount.
All right. There's probable cause. He has a slew of priors for petty thefts as well as other charges. I'll set a bond on count 1, petty theft, 2 or more convictions, $5,000. Count 2, petty theft, 2 or more convictions, $3,500. Stay out of that CVS. They don't want you there. Don't go there. And if you go there, you can face additional charges, sir. You'll see your judge on Monday. Have a nice day. Thank you.
For your time and consideration.
Thank you.
Your Honor.
Have a nice day. Next, we have Lazaro Acosta Diermis.
He has a fugitive hold from Broward, no bond.
Thank you. Good morning, sir. Do you speak English?
¿Habla inglés, señor?
Spanish, this is Acosta de Armas, yes? Yes.
Sir, you were arrested for retail theft. It says multiple items, 30 days. I will appoint the public defender's office for you.
Muy bien, señor. Buenos días. Aquí consta acusación de hurto en tiendas o ratería de tiendas, múltiples artículos en plazo de 30 días. Le asigno el abogado de oficio para que les represente.
Sir, you are ordered to stay away from the Home Depot store at 11905 Southwest 152nd Street in Miami, Florida.
Muy bien, señor. A usted se le ordena estar alejado de la tienda Home Depot, ubicada en el 11905 del suroeste, 152 calle en Florida.
You're not allowed to go to that store and you must stay away from there, sir.
A usted no se le permite regresar a esa tienda y tiene que estar alejado de ese lugar, señor.
All right, there's probable cause for the charges. It looks like you should have been charged multiple counts, but they charge it this way.
Muy bien, tenemos motivo fundado para esta acusación, la cual parece debía haber sido múltiples acusaciones, pero decidieron hacerla de esta manera.
I'm setting your bond at $5,000. Have a nice day.
Establezco su fianza en $5,000. Tenga buen día.
Next, we have Tristan Meyer.
I think it's a structure, the value of the bike's listed.
Where's Mr. Meyer?
He's present.
Good morning, sir. You were arrested for burglary to an unoccupied dwelling, but it should be a structure and grand theft from a curtilage. I will appoint the public defender's office for you.
Requesting a bond, the defendant's got an open misdemeanor, also a 366 for theft from earlier this year.
So you were ordered to stay away from the building or apartment complex or structure at 7125 Southwest 59th Place in South Miami, Florida. You are not allowed to go to that store and you must stay away from there. I'm setting a bond. Count 1 burglary
I
is
would ask
20.
if you would consider the TAP program.
I can, he has a
Mr. Meyer is
conviction.
currently homeless. He does not have funds for a bond.
He has a 10-year prison sentence going back in 2005. He has a January conviction for 366. This year, count one is $2,500 and count two is $2,500. Have a good day. Next is Eric McGlory, page 5. Good morning, sir. You were arrested for pursuant to an arrest warrant. It's charging you with trafficking in MDMA, 4 counts, and possession of a controlled substance.
Wow.
With possession with intent to sell a controlled substance.
I don't have the arrest warrant yet.
Let me see if I have it. If I do, I'll send it to you.
Eric says he sent it this morning. It's the first buy walk was February 11th. He's selling MDMA to the undercover.
I
Then
don't know who you sent it to.
Yeah, I don't
all
think
right, I'll pass it. Have a seat.
I have it, Miss Corey. I'll send it to
Okay.
you.
Thank you.
I got a phone.
Then there's Raheem Hale.
He's on felony bond.
Hold for F-25 18704. Good morning, sir. You were arrested for
Judge,
possession.
we passed one?
Who
Mr.
dat?
You have Mr. Hudak?
Number 14.
Not yet, Your Honor.
Oh, okay. So we're passing Hudak. 14. Okay, so Mr. Hudak's not here yet, so we'll go to Mr. Hale.
All right, 1 second.
Yeah,
Mr.
Mr.
Hale, you were arrested. Sorry. You were arrested for possession of cocaine and trespass after warning. I will appoint the public defender's office for you. There's probable cause for the charges. Anyway, you are out on felony bonds. Hold for F-25 15879. You'll see that, Judge, on Tuesday, because Monday's a holiday. Also, stay away from the McDonald's restaurant at 1016 West Flagler Street. You're not allowed to go to that store. You must stay away from there. And I'm setting a bond. Count one is $2,500. Count two is $500. Have a nice day. Next is Joseph McKee. Page 6. Good morning, Mr. McKee. Sir,
He's
you
on
were
felony bond.
You were arrested for possession of a firearm, weapon, or ammunition by a convicted felon. I will appoint the public defender's office for you. You're also out on felony bond. Hold for F-25 17708. Right, 08? Yeah. So let me see. He has videos he posted on social media of him holding a firearm. They executed a search warrant and they found one of the firearms he was holding. There's probable cause. Your bond is $7,500 and you'll see your judgment Tuesday. Have a good day.
Okay, so I have a little bit of a choose your own adventure to offer you guys. So we can continue with Judge Glazer, maybe look at some landlord tenant. Judge Washington's got a criminal docket. Judge Disappointment has a couple things going. So we have options. Or we can do something new. I'm looking right now out of Lenawee County at the Lenawee Probate and Juvenile Court, and it sounds like there is a custody hearing where there's a guardian ad litem involved and possibly removing custody from the parents. That would be a different kind of court. If you guys want to check that out, put a 1 in the chat. If you want nothing to do with it, put a 2 in the chat. I'll give you a couple of minutes to sound off on that, and then we'll figure it out from there. So just let me know. 1 if you want to look at it, 2 if you don't.
No, she's very just absent. I won't, just one friend, I didn't bring him along. Okay. You're welcome.
Ready to go.
Thank
you.
Thank you. That one. You know, I defended a first-degree murder case in this courtroom. We got a good verdict. The judge was Chambro. ¿Te acuerdas de Chambro? Yeah, it was, but it looks a lot better than it used to. I guess they fixed these chairs.
But I don't use this. Go test.
All right, everybody, good morning. And are we on the record?
Yes, Judge.
Good morning, Your Honor, yes.
Good
Good morning, Your
morning.
Honor.
Okay, what case were you last on?
We're on Mr. Pfeiffer, Tevin Pfeiffer, on page 7, number 18 of the calendar.
Good morning, Mr. Pfeiffer. How are you today?
I'm all right.
All right, in case number F2518713, you are being charged with the following offenses: 1 count of armed trafficking in oxycodone. You have a 2nd count. You have a 3rd count, which is selling cannabis within 1,000 feet of a church or a convenience store. And that's a 2nd-degree felony. The first 2 are punishable by up to 30 years in prison. The second one, 15 years. And then you have a 4th count of selling narcotics without a prescription. That's punishable by up to 5 years in prison. All right, let me hear from the attorneys, please.
So Judge, it's the state's position that there's probable cause. It's armed, requesting that the defendant be held without bond on the first 2 counts.
What saith the defense?
Judge, with regard to being armed, the police are just saying that there was a firearm that was discovered in the residential search warrant. However,
Yeah, I don't really see the arm. I'll be honest with both of you. If you want to elucidate me a little bit.
I
please
can
do.
have the detective log on.
I beg your pardon?
I can bring the officer in for sworn testimony if Your Honor is not
Okay.
finding PC.
Well, I don't see where, I
Okay.
mean, do you see it within the 4 corners of the document?
It talks about the gun. It says 1 Glock firearm was recovered as a result of the residential search warrants.
Okay, I don't find that he's armed. I don't think you need to bring in the detective unless he's gonna testify that the defendant had it on him.
But Judge, the state can prove armed through constructive possession.
Okay,
based
I don't see
on-
it.
Can I bring the officer in, Judge?
When?
I can have him log on in the next few minutes.
Okay, I don't want to turn this into an all-day discovery session. I don't think that's fair to anybody in this hearing.
Can we just pass it? I think the officer also, if Your Honor is not going to hold him without bond, I think the officer wanted to be present to address the bond amount.
Well, then you should have had him ready to testify. It's not obvious
I
on the
didn't think
document
there
that he had
should
the,
be an issue, Judge.
don't interrupt me, please.
Sorry.
When you read the 4 corners of the document, there doesn't say anything. There's a gun in there. It doesn't show he had it on him.
Judge, can we please pass the case? The officer can be present.
What do you think, Ms. Curry?
Judge, I would ask if you would just go ahead and set the bond at this point, Judge. There's nothing.
Well, you know, the reason that I am
Not in the 4
concerned
corners.
about it, and I want to give the officer an opportunity to testify about it, is because this appears, and maybe I'm thinking that this is a long-term investigation. So go ahead, bring in the officer. We'll pass it.
Thank you so much, Judge.
Okay, so I have the Lenawee County thing queued up, but I want to ride with this guy for just a couple of minutes longer and see what he's all about. And then we'll get to that. So let's just hang here for a few more minutes.
English?
All right, this is case number, F2518715. Sir, you're charged here with 1 count of selling cocaine within 1,000 feet of a school and possession of cocaine. First count is punishable by 30 years in prison. The second one is punishable by 5 years in prison. I hereby find probable cause. As to both counts. As to count 1, I'm gonna make the bond $15,000. As to count 2, it'll be $5,000 with a stay away order from the location at 5900 North Miami Avenue, Miami, Florida, 33127. Good luck to you, sir.
Judge, that's his address. We would ask that you not do a stay away from his.
Well, if he was selling the cocaine from there, he can't go back. Let's go to Willie
Judge,
Miller
can he
now.
at least return to get his belongings if you're gonna require that he leave his home?
Well, supply me with a stay away order and I'll put in there that he can go back one time to obtain his property.
Judge,
In,
I don't
in
have
the
a
company
stay
of the
with-
police. Listen, I'm not gonna argue every case.
I'm
I
not
don't-
here to argue with you, Judge.
But
I'm
that's
just
what you're
saying,
arguing with me right
if
now. I
you're
just
giving
told you,
him a stay-
supply me with an order that I will give him permission to go one time accompanied by the police.
Judge, I believe it's on the orders that the state attorney asked for, and there should be a box on.
No, I didn't get one. I don't have one.
Okay, Judge.
Let's go to Willie Miller now. Is this Mr. Miller or not?
No, Judge, I need to make a note so I don't forget to get you an order after court, Judge. So please, give me a moment.
I'll be in chambers. Let's call up the case of Willie Miller, please. Good morning, Mr. Miller. How are you today? This is case F25-18716. Corrections gave me a note saying he's out on bond in front of Judge Stuzen in case F25-10695A as in alpha. He will be held. Mr. Miller, can you hear me?
Loud and clear, sir.
You're charged with one count of selling cocaine. That's a second-degree felony punishable by up to 15 years in prison, and one count of possession of cocaine punishable by 5 years in prison.
The good part about it, Your Honor,
I beg your pardon, sir? Ms. Corey, I can't hear what he's saying.
Judge, it was letting him know he should not be talking about the facts of his case while we're here in court today, Judge.
Right, I do find probable cause. As to count one, I'm gonna set the bond at $10,000. As to count two, it'll be $5,000. He's to be held until he goes back in front of Judge Susan. Good luck to you, Mr. Miller.
So yeah, guys, we're just gonna hang here for a while. This is entertaining. And honestly, like I said earlier, there's not a metric ton going on out there today. I do have the Lenawee County thing queued up. We'll go there at some point because it's a different kind of court. But I'm not inclined to leave this guy right now.
You God?
Yes, Judge.
Good morning. How are you today?
Good morning. How are you, Judge?
I'm doing good. You want to go ahead and proceed on the questioning on the issue of the firearm?
Let's wait for the defendant, Judge. Corrections still hasn't brought him. Pfeiffer.
I didn't hear you.
Judge, can we wait for the defendant to be present?
Of course. Ms. Corey, would you let us know when the defendant is there with you?
He's your judge now.
Mr. Pfeiffer, are you there?
yes, sir.
All right. We're going to have the detective testify right now regarding the issue of the firearm.
Right, Detective, what was the probable cause to get the search warrant?
The defendant was selling narcotics out of his residence, and he sold narcotics twice to an undercover police detective.
Does he live there?
It looks like he does live there. He had clothing, shoes. He was sleeping on a sofa bed there, and he had a medicine bottle in the closet.
Okay, where were the drugs found within the house?
All over the house.
Yeah,
Literally.
Sorry, Detective. I read the A form. That's not the issue here. The issue here is you want to charge him with armed. Detective, did you find the firearm on the defendant?
No, it was within the home.
Okay, do you know?
Inside,
Do you remember exactly where inside the home?
it was in the kitchen on top of the stove, just on top of the stove in a holster.
All right, do you have any information that that gun was his?
Besides the fact that it was in the home that he was in, no.
All right, is it being forensically examined for any fingerprints?
Yes, it will be forensically examined for DNA.
All right. Anything else from the state?
Right, and where was the gun found in relation to the drugs?
Like I said, the drugs were found all over the home. Literally, just pretty much in every room. Um, and the firearm was found on the stove in the kitchen, and directly across from that was the defendant's cell phone that he was asking for officers to go get from inside of the home. Cell phone and iPad.
Anybody else in the house?
No, he was a sole occupant.
All right, no more questions, Judge.
Corey, do you have any questions?
No, Judge, I would ask that you find no probable cause for armed trafficking.
All right, Detective, I want to thank you very much. I don't find probable cause for armed trafficking. That very well may change after the forensic examination of the firearm. But I want to thank you for your candor and sorry for the inconvenience this morning.
Judge, in light of the fact that the court is going to set a bond, I don't know if the detective wants to give any input as to the bond amount, detective?
Yes, Judge. The defendant during the interview, he stated that he didn't live there. Obviously, we've been watching him for some time. We saw that he does live there. He was claiming to be homeless. If he could provide a home, we would ask that he be on house arrest because he said he was homeless. I don't know. I'm not sure where he's gonna live. And given the light of the facts and the drugs that he was selling, we ask that he have a elevated bond and be held for nephew.
Well, he'll have an elevated bond. I mean, you abundantly make clear that this was a long-term investigation, at least going back in for a while, and so I will give an elevated bond. Anything else from anybody? Ms. Curry, you want to say anything?
No, Judge.
Judge, just FYI, it's going to be in your division, or whatever that's worth.
Wonderful. So I'll see him again.
And he has
Yeah.
no priors, Judge.
Okay. Well, he's been arrested before. He's been no pros before in the other cases, but given the equities and the totality of the information that's been provided by the detective, I will set the bond as to count one at $50,000. As to count two, I will set the bond at $25,000. As to count three, I will set the bond at $25,000. As to count four, I'll set the bond at $5,000. And that's on case number F25-18713. And if he makes the bond, it'll be with a GPS monitoring device. Sir, while you're being charged right now, you are not to possess any firearms or any narcotics or anything that's considered contraband. Did the clerk have a question for me?
No house arrest?
Total lockdown. Yes, sir. And on F25-18714, he's got 2 counts. He's being charged there with possession of a controlled substance with intent. One is for oxycodone, the other one's for Percocet. You're facing 15 years per count in that case, and I'm charging you with 15,000 as to count 1 and 15,000 as to count 2. Good luck to you, Mr. Pfeiffer. Same conditions apply on both cases with the GPS monitored device.
Your Honor, is there gonna be a nebbia?
No, ma'am.
Thank you, Judge. May I be excused?
Yes, sir. Thank you, Detective Bellinger. Stop on by sometime up on 7-2. I understand Mr. Pfeiffer is going to be in our division, so we'll get to see you.
Yes, sir. Be safe.
Thank you. You too. Next case we have is Jose Carlos Moya Lopez, case F25-18717.
Spanish interpreter, please.
Thank you. We have the interpreter under oath.
Yes, Your Honor. Good morning.
Good morning. Thank you for being here. Mr. Moya Lopez. Mr. Moya Lopez, I can't hear him.
Señor Moya López.
Dígame,
El juez. Buenos días.
buenos días, ¿cómo usted está?
Bien, ¿usted qué tal?
Bien. A ver si me podía soltar, oficial, que me cogieron comiéndome una subita ayer, compadre, en el Walmart, que tenía hambre.
Señor. No diga.
Don't worry, Ms. Curry. I rule that is not to be used against him. Okay, I do find probable cause. I'm looking at his priors. He says he's told the police he is homeless, Ms. Curry. I'm concerned he doesn't have a place to stay.
I would ask for
Entonces se indica su señoría, determino motivos fundados, señora Curry, que es la abogada defensora al lado suyo, señor. El señor le indicó, aquí dice a la policía que él estaba desamparado, o sea que no tenía hogar.
No, está.
Would you consider the TAP program, Judge? They would help
Yes.
you find a place to stay.
Su
Yes.
señoría, por favor, tome en consideración el programa TAP. Ellos le ayudarían en cuanto a tener un lugar a donde vivir y el juez dice que sí.
TAP and the alternate bond will be $150.
Muy bien, se le asigna salida con supervisión del programa TAP y alternativamente tiene una fianza de $150.
And a stay away order from that location where he was arrested?
Y una orden de alejamiento además del lugar donde usted fue arrestado.
Buena suerte, caballero.
Judge will need a future court date.
September 29th, Your Honor.
Did you hear that, Ms. Curley? September 29th?
Perfect, thank you.
Thank you.
La próxima fecha de tribunales para usted, señor, es el 29 de septiembre.
Buena suerte. Ms. Curry, I have a very small screen. I can't really see the defendants. Normally I can see them and I can see their face with the booking photo. Is this Mr. Courtney?
Yes.
Good morning, sir. How are you today?
Okay.
Mr. Courtney, in case F25-18720, you're charged with one count of aggravated battery on a person 65 or older. And that's punishable by up to 30 years in prison. And count two, you're charged with strong arm robbery. I'm reading the probable cause affidavit and I do find probable cause.
Judge, with regard to probable cause, there's nothing indicating the alleged age of the victim.
No, you're correct. I find probable cause as to aggravated battery.
In addition, Judge, it indicates that the Mr. Courtney spoke to the police and told him that the alleged victim threatened to hurt him with his knife. And so essentially, Mr. Courtney is accused of hitting the alleged victim and then disarming the alleged victim of the pocket knife.
All right, I hereby find probable cause for aggravated battery. I'll set the bond on count one at 15,000. As to count two, I'll set the bond at 10,000. And there'll be a stay away order from the alleged victim in the case, Mr. Luis Rojas. Good luck to you, sir.
Judge, Mr. Courtney is a veteran, appears are you homeless?
Yes.
And he's homeless. Would your honor consider any reduction in the bond for him?
No, ma'am. Thank you for your service, sir. Were you Army, Navy, Marine Corps? What were you?
Army.
So was I. What was your MOS?
Infantry.
What's the MOS for that?
11 Mike.
Actually, it's 11 Bravo. But thank you for your service.
Yeah, I was mechanized infantry.
Well, thank you for your service.
I will say this. This guy makes Glazer look positively charming and somebody you'd really want to spend time with. I'm just saying. Back to Judge.
Thank you.
And then this is Delonte Jackson, correct? Yes.
I'm gonna use.
Mr. Delonte Jackson, good morning. How are you today?
All right, sir.
Sir, you're being charged in case F25-18724 with selling crack cocaine within 1,000 feet of a school and possession of cannabis, 20 grams or less.
Judge, I would ask you to find probable cause for simple possession only. There's nothing indicating an actual sale.
Let me hear from the state.
1 second, Judge.
I beg your pardon?
If I could just reread it 1 second, please, Judge. It says he was observed selling. Let me just look at it one more time. We observed, right, it looks like the officer saw what appeared to be a hand-to-hand.
They don't stop the alleged person that they're saying he did a hand-to-hand with.
Okay, I find probable cause for possession of cocaine. I'll set the bond on count one at 5,000. I'll RR him on count two, the possession of cannabis. Sir, I'm ordering you to stay away from Laura Saunders Elementary School. You're not to come anywhere near that school. Is that clear? Within 500 feet of that school, you get caught, you're gonna be arrested.
Yes, sir.
Good luck to you, sir.
Thank you, sir.
Scurry, be kind enough to tell me who else is coming up there.
This is Romel Gavarati, English or Spanish?
It doesn't matter.
He speaks both.
All right, sir, good morning. How are you?
How you doing, sir?
I'm doing good. On case number F25-18728, you're charged with one count of aggravated assault with a deadly weapon and 1 count of battery in a domestic violence case. The first count is punishable by up to 5 years in prison. The second count is punishable by up to 1 year in the county jail.
Can I talk?
Okay, hereby find probable cause. I'll set the bond on count 1 at $10,000. On count 2, I'll set the bond at $5,000. There's a stay away order. You can have no contact with the alleged victim, direct or indirect. Is that clear, sir?
Judge, can he return one time to get his belongings?
Yes, ma'am. I've initialed the paragraph 4. He can go back, but only to pick up his stuff and only in the presence of law enforcement officers. Mr. Guarrete, is that clear?
Yes, sir, it's clear.
All right, good luck and just be patient on your case, all right? Let's call up Jose Antonio Ortiz if he's there. Ms. Curry, you gotta let me know, is he there?
This is Jose Antonio Ortiz. Is English fine for you?
Yes.
Yes.
Mr. Ortiz, good morning. Do you understand me?
Yes, I'm understanding.
Okay, Mr. Ortiz, in case F25, you're charged with F25-18735. You're charged with 2 counts of possession of cocaine. One is possession of cocaine, the other one says crack cocaine. They're each 3rd-degree felonies punishable by up to 5 years in prison.
So Judge, we saw co-defendants earlier, states requesting tap on count 1, ROR count 2.
He was with the other co-defendants on the patio, Judge. so
Yes,
you-
ma'am, that's fine. Tap as to count 1, alternate bond will be $150 as to count 1, and ROR as to count 2.
And
Is there anything else, ladies?
Yes, a future court date, September 29th at 9
Yes,
o'clock
ma'am.
for Judge Rodriguez.
Yes, ma'am.
Thank you.
Good luck to you, sir.
Which I think corrections is trying to take a case out of turn.
Can they tell us which one it is?
We had previously passed it. Defendant's last name is Hudak. I'm going to promote corrections to panelist.
Okay, I have it here. I don't know, but it's, take your time in finding it. It's Michael Hudak. Case number F25? Thank you. See, I learned something already. I didn't know that's what that was. Ms. Curry, let me know when Mr. Hudak is there, please.
Judge, I think he's on Zoom. They'll have to turn on their camera. What page is Mr. Oh, there was 14.
Our clerk says it's on page 5.
There's Mr. Hudak on Zoom, Judge. Mr. Hudak, can you afford to hire an attorney?
Yes.
Have you hired private counsel? Have you hired one yet?
No, I haven't had the chance to.
Mr. Hudak, good morning. How are you today? I'm Judge Milian. I'm presiding over the bond hearing for you. In case F25-18700. Mr. Hudak, would you be kind enough just to tell me, I'm seeing your picture, but it's rather small. Tell me your full name.
Michael Andrew Hudak.
Good morning.
Good morning.
On count 1, you're charged with burglary of an unoccupied dwelling. That's a 2nd-degree felony punishable by up to 15 years in prison. As to count 2, you're charged with 1 count of grand theft. That's punishable by up to 5 years in prison. And you have a second case here, F25-18699. On that case, you're charged with dealing in stolen property. That is punishable by up to 15 years in prison. And you have a second count, which is false verification of an altered item at a pawnbroker. That's also punishable by up to 15 years in prison. Reading the A form, Mr. Hudak, I do find probable cause as to all 4 counts. Can you afford a bond, sir?
Yeah.
Would you please address me? I'm a judge, and address me
Yes,
correctly,
sir.
please?
Yes, sir.
With the same respect that I address you.
Yes, sir.
All right. Mr. Hudak, as to count one, I'm setting the bond at $10,000 on case F-25-18700. As to count two, I'm setting the bond at $5,000. That will also be with a stay away order from the victim's home. His initials are CD at 650 Northeast Second Avenue. As to your second case, F-25-18699, I'm setting the bond as to count one at $10,000. As to count two, I'm setting the bond at $10,000. I'm also ordering you to stay away from any pawn shops. If you're caught at a pawn shop, it'll be a violation of a court order. I'm not appointing the public defender right now because you said you could afford an attorney. And this case is going to be going to Judge David Young. I'm sure that if there's an issue with the bonds, that you can probably get your attorney when you hire him to reconsider the bonds. Any questions?
No, sir.
Good luck to you, Mr. Hudak.
Thank you.
Ms. Curry, be kind enough to tell me who the next defendant is that's coming up.
Judge, this is Amir Akbarnia, correct?
Akbarnia. Mr. Akbarnia, how are you today?
English, how are you?
I'm doing good. You're charging case F-25-018737 with one count of possession of cocaine or crack cocaine, and then they charge you with one count of tampering with physical evidence. Those each are third-degree felonies punishable by up to 5 years in prison. You also have one count of misdemeanor charged with drug paraphernalia. It's a first-degree misdemeanor. Sir, could you afford a bond?
No, sir, I can't.
State's not objecting to tap, Judge.
Okay. Well, I find probable cause and I will give him tap. As to counts 1 and 2. As to count 3, I'm just going to ROR him. Alternate bond will be $150 per felony charge. I know you're homeless right now. I wish you good luck. Ms. Curry, see if you can give him any referrals to any shelters who might be able to help him out.
Yes, Judge. And his future court date would be September 29th at 9 a.m. before Judge Ariel Rodriguez.
Yes, ma'am.
Thank you.
Okay, I'm gonna keep an eye on them, but we should probably change things up a little bit. Let's go do that thing in Lenawee County. So again, since it's been a little bit, this is a juvenile court in Lenawee County. This will be Judge Catherine Sala, and it sounds like a custody thing where perhaps they're talking about removing custody from the parents. But let's give it a look. Something we don't normally do here. So let's enjoy.
Permanency planning hearing and request for termination of parental rights on this case. May I have the names of our participants, please?
Good morning, Your Honor. Nicole Underwood, lawyer guardian ad litem for the minor child.
Ms. Saja Thomas, counsel for the department. Ms. De La Garza.
Brandy De La Garza, the foster care worker from Fostering Solutions.
Michael Brooks, I represent Harold Hollis, father of the child.
Harold Hollis. Michael McFarland, representing mother.
Eric Hollis.
Thank you.
Thank you. All right, Ms. Thomas, if you could, I think your microphone is a little quiet this morning. But other than that, what I have in my notes, ladies and gentlemen, is that we are at the point where I'm just looking for your closings, and then I would make my decision. Is there anything else that we need to address on the record before we head into that?
Not from my end, Your Honor.
That's also my understanding, Judge.
Okay. All right, Ms. Thomas, let's start with you. We're going to let Nicole Underwood, our guardian ad litem, go last so she can hear everything everybody has to say before I listen to her recommendations.
Thank you, Your Honor. Majority of my closing, I would rely on my petition that was filed in this matter in July, asking the court to terminate the parent's parental rights so the child can be freed for adoption. Majority of the petition relies on the fact that the parents have either not complied or engaged in their case service plan or have failed to benefit from it. And under MCL 712A.19B3 CI, we do have two parents who have been respondents for 182 or more days since that initial case service plan was entered. And the conditions that led to adjudication, this court will recall, there were concerns about domestic violence in the home. At first, there were allegations of some severe physical domestic violence, and also about potential drug use, and then the living conditions for the child. And Your Honor, during this what we've not been able to really thoroughly develop as relates to the parents has been the substance abuse component. Ms. Hollis lately, or more recently in the last 2 review hearings, I believe, has finally admitted to that. And Mr. Hollis, despite having those 3 positive screens, continues to maintain he does not have a substance abuse problem. However, he did not provide any information or evidence to us, or even provide us the name of the medications that would provide a false positive for methamphetamines. During this case, we've also had numerous reports from therapists indicating that there is concern about the potential power and control dynamic within that relationship. And just a few days ago, we've heard from both parents that they do not believe that there are any issues in their relationship as relates to domestic violence, because verbal or oral arguments are not domestic violence, since it's not physical. And from the parents' perspective, their issues have never harmed their child. And I think that's the real crux of where we have to rely on the information we have from the service providers, the trauma assessment, the psychologicals, that there is a harm to this child, that this child has experienced a significant amount of instability and a hostile home environment when she was with the parents. The police had found her hiding in a ditch with Miss Hollis, and to say that she was not ever harmed is really concerning, that there's no awareness of how their behaviors, their words, and their actions towards one another and to others in front of the child can lead to emotional harm. As this court would recall, parenting time was suspended back in early January of this year, based on reports from Ms. Moore and from the agency that there were some inappropriate behaviors, not necessarily towards the child, but in front of the child towards other adults in the room. One of the things that stood out to me from this case that I recall was Mr. Hollis was upset about the clothing his daughter was wearing, referred to it, I think, as secondhand or trashy clothing in front of her. And while that might have been his opinion to say it in front of his child, I think that there's a lack of awareness of what that can do to a little one's psyche. Moreover, we've heard from Ms. Hollis numerous times now, or at least since her last review hearing, about her intentions to get inpatient treatment. And I want to say that she's probably in a contemplative state in her recovery, if she has maintained her sobriety the last few days. And we don't have any tests to prove that. We don't have a substance abuse assessment to kind of go through. There's been a real lack of acknowledgement of the issues at hand, Your Honor. As relates to the best interest, I think that this court has significant information within the court record to prove by a preponderance of the evidence that it is in this child's best interest for her parents' parental rights to be terminated. Although she is in a relative placement, and I know that this court must consider that, these parents have indicated on the record and by their conduct have indicated that they do not want to have a relationship with the relatives who are providing care for their daughter. And that has not availed them to alternative options for permanency, like a guardianship, or being able to be around her more during family functions, or those holidays that we sometimes will get when we have those family placements. So in this case, that does not weigh against termination. I would like to give credit to the parents for updating their home in order for it to become more prepared for the child to come home, Your Honor. But at this time, it's been a year and we still have limited acknowledgement and progress. And so I don't believe that at this time that their home environment would be appropriate for the child. The child is in a home that provides for her needs. She has developed strong emotional attachments to the caregivers and to the other relatives that are in that home and their extended relatives. And I believe that the parents' lack of compliance and benefit from their case service plan speaks volumes as to their parenting ability. And Your Honor, for those reasons, we are asking the court to grant the relief requested within the petition. Thank you.
Mr. McFarland, would you like to go next?
Sure. One thing I'd like to point out is the operative word of the attorney for the agency is that parents' actions can lead to emotional harm to the child, not that it did lead to emotional harm of the child. We've had no expert testimony during the trial that I recall that their actions, verbal actions, led to any emotional harm to the child. Their house is much better than it was, and the agency is in no position to immediately return the child. I think this case is, we're taking an analogy, is like a big cruise ship. It's very hard to get turning. And once it's on course, it's very hard to veer off course. And I think these parents have made that turn straight. That mother has indeed acknowledged that she has a drug issue, and she wishes to address that. That's a really big turnover. Of course, they've been denied parenting time for some time, but when they last met with the child, there still was a bond with the child, and there's been no testimony that there wouldn't yet be a bond with the child if they were to have parenting time, Your Honor. Couples argue. I don't know any couple that doesn't argue. Walking away, like this couple did during the last argument, seems to be a proven course that's taught many times, to walk away from arguments. Take a break. Appears to be what they did. The client did testify as to the best interest factors in this case. They do have some physical issues. I haven't heard really any type of accommodation for that. At this point, the question is there an expectation that in a reasonable amount of time, they can get their act together? And I think they're well along that path. Their income seems to be sufficient. They've made improvements on the house. DHHS, per policy, they don't remove a child if parents are functional addicts, Your Honor. Mother seems to be functional. She seems to be, we haven't heard any stories of any reports of her being passed out, of her in a ditch as the initial allegations were on this case. We haven't heard any of these bizarre ideations or behaviors. We believe that their expectation can be met by the parents, my client, that they can achieve the goals of the case service plan. We're asking that the court not terminate the parental rights and restore parenting time so they can come to a closure on this case. Thank you, Your Honor.
Mr. Brooks.
The 1950s, there was an anthropologist considered to be the finest educator in the world at that time, named Margaret Mead. And she had studied many different cultures, found that when measured against what we would consider the norm, they deviated considerably from the norm. But she didn't consider those to be deviant behaviors because they were not presenting problems to the culture as a whole, their culture as a whole. Now, in our case, I will be the first to acknowledge, it's no secret, that Harold Hollis is frustrated by being in this situation and thinks that the taking of his child for the length of time he has is an injustice. Harold tends to express his frustration in a way that is not, how would I put it, socially acceptable in many ways. And he has unintentionally, I believe, communicated an attitude that he does not in actuality share. He has a stable relationship with his wife. They have a child, now a 3-year-old child together. I can tell you that the way I met Harold Hollis was he was operating a business of his own, and I hired him to do some work in my yard, which he did a fine job, and I paid him for it, no complaints. But if you were to ask him how he feels about me, or this court, or the DHS and its staff members, you would probably hear something that sounded to our ears offensive. And that can lead to a false impression. The fact is, he has not harmed his child. He has not harmed his wife. To my knowledge, he's never harmed anybody. But if you listen to him talk, you'd think he was a semi-controlled bear of a man. He's not. He's just a normal guy with a limited education and a limited vocabulary who uses the vocabulary he knows how to use in a way that's offensive. I've had many cases where the client really wasn't that bad, but they just weren't going to cooperate verbally and accept the authority of a court or the department. And I think verbally that's what you're getting from Harold, but I don't think he really is acting that way. And I would hope the court would take that into account when deciding whether or not he and his wife should have another chance to raise a child. Thank you.
Ms. Underwood.
Thank you, Your Honor. As I say in many of these hearings, termination trials are never easy, and it is my job to look out for what is in the best interest of each minor child that I represent. It's hard to watch parents who come back review after review and fail to really see or acknowledge any type of wrongdoing that has impacted their child, and acknowledge any reasoning as to why we're all involved to the point that we are. While I appreciate that the parties have done some work when it comes to parenting classes, the blatant disregard to acknowledge substance use on behalf of Harold continues to be a problem. He's attended a substance use evaluation and declined to indicate he had any substance problem, so there was nothing that could be done there. And Miss Hollis did the same thing. It took her a year to acknowledge that she had any substance use disorder or drug problem. And when she did in the June hearing, she said she would be going on Thursday to check herself into inpatient. And here we are, it's almost September, and she hasn't done anything to acknowledge that issue or to further it. I confirmed with CMH, there is not a 3-month wait list for substance use disorder inpatient treatment. It's at most a 2-week wait. So, I mean, realistically, Ms. Hollis could have been at the near end of her substance use disorder treatment and on her way to recovery. However, she's still sitting in the courtroom today and hasn't taken any steps in order to address that issue. It's interesting that Mr. McFarland said that the parties now know how to deal with conflict. They just walk away, yet he failed to mention the fact that his client locked Mr. Hollis out of the house, and then Mr. Hollis proceeded to break a window to get back in. There continues to be police involvement. There continues to be arguing and fighting. Again, the parties are downplaying it now, but the police reports in the initial petition indicate otherwise. The dysfunction in their relationship is far beyond just fighting. It's not functional or healthy or in the best interest of any child. Mr. Hollis's refusal to participate in any services, again, shows his stubbornness is winning out over taking the steps and putting in the work to get his daughter back. And that's unfortunate. But again, the department can only help provide services and give options and assist with those things. They can't make the parents do the work here. And I believe the department has gone above and beyond to try to assist with connecting the parties to these services in order to try to get their child back. And they have, again, Mr. Hollis has done very little. And Miss Hollis, again, has failed to treat her mental health and her substance use disorder. She's been hospitalized. Miss Hollis has been hospitalized for her mental health and even had some paranoia or some sort of hallucinations during her psych eval. So again, her mental health is still also untreated, or at the very most, only at the beginning, since she just started engaging in services again. Again, Your Honor, I never really like to recommend termination. However, in this case, the parents have done very little to benefit their daughter. And if she were to be returned to their care today, she'd be in the same situation that she was in a year ago. And that is truly not in the child's best interest. She is in a place now with relatives that care for her, that provide her with her needs, that provide her stability, consistency, and a healthy family environment. So again, it's unfortunate that we're here today, but again, I do think that it is in the child's best interest, based not only on the petition and the lack of services that the parties have engaged in, but also it's unfair to this child to continue waiting for permanency while her parents may or may not put in the work in order to better themselves for the benefit of their child. So I would ask that the court proceed with termination of parental rights today. Thank you.
Thank you. Well, the court finds all interested parties were given notice for purposes of today's review, permanency planning hearing, show cause hearing as it relates to both parents, as well as the request for the court to terminate parental rights of both parents. As it relates to the review, I do find reasonable efforts towards the goal of adoption at this point are being met. The secondary goal remained, or not necessarily the secondary, but the alternative goal remained reunification. And to her credit, Ms. De La Garza continued to try to keep track of the parents and to refer them to services and to monitor those services. And those details are outlined in the court report, as well as her testimony that was taken earlier on this review hearing. A couple of good examples are tracking Ms. Erica Hollis's attempts at rehabilitation around substance use, and how that is playing out as it relates to her progress in that area. That's inextricably tied to the progress in the area of her mental health treatment. She's been in and out of several different services, and Ms. De La Garza continued to report on her efforts all the way up until this last hearing. She also continued to try to keep track of Mr. Hollis. Unfortunately, that included keeping track of the times that the police intervention was necessary at the home of the parents. But technically speaking, all of those things are considered reasonable efforts towards the alternative goal of reunification, which is tracking the client's progress on their case services plan around treatment for substances, mental health issues that were highlighted at the outset of the case and continue to be issues as we went through the reviews all the way up until this last year, regardless of the goal change. at the hearing before this one. It also included tracking the progress on the Orchards Family Assistance Program. And of course, all the documents that were supplied in support of her report. Regarding that item is also certainly in compliance with her obligations to the family, and I appreciate the advocacy of our attorneys this morning and in prior hearings. As it relates to the show cause for failure to follow the case services plan, that is inextricably tied to the court's findings as to whether or not there's been progress made on those case services plans. The burden as it relates to a show cause is obviously similar to a burden in a criminal case as it relates to the burden, since a show cause could potentially result in incarceration or some other fines and costs associated with contempt of court for failure to abide by the court's order. I do find that objectively speaking, and by their own admissions, Mr. Hollis is refusable to engage in case services around substance abuse, in counseling, and even communication with Ms. De La Garza, visitation are all irrefutable proofs that he is, and he's told us that he doesn't trust anybody and that he has frankly, no intention of engaging with the services that have been instituted for him. There was some limited testimony that he's engaged in counseling, but as I really looked at those proofs, I think I only saw like 2 visits in the last report period, and that's over the course of the entire case time frame. Ms. Erica Walker is not currently engaged in services. She indicated at the Orchards family, she indicated to Tyler Karwicki at the tail end of her Orchards Family Services planning that she wished to check herself into a rehabilitation program, and that was why they closed their case. And that's what's cited at the back of the closing report on that. She herself told us she was going to go to rehabilitation and try to get some treatment for substance abuse. She's admitted on record that she's using methamphetamines as recently as 5 days ago. So those are clear indications that she's disregarded her case services plan, and that would be considered contempt of court. As it relates to the consequences for a contempt of court, I'm simply going to note as part of today's findings and in support of my decision to terminate the rights of both of these parents, that is certainly a contributing factor to the court's decision in agreeing that there is clear and convincing evidence to terminate their parental rights. So I'll note that in the court order as it relates to the request for review of the show cause. As it relates to the termination of parental rights, the court is asked to look at that as a 2-phase series of findings. The first is to determine whether there's clear and convincing evidence to support that the statutory grounds for termination of parental rights has been established. Second is to determine if it's in the child's best interest to terminate the parental rights by a preponderance of the evidence. Sections of the statute that are asked of the court to consider do include the provision that relates to failure to complete case services and whether or not there is a time frame, a reasonable time frame during which the parents could potentially comply with those services and benefit from those services. And that's found under MCL 7128.19B3CI. In this case, certainly the respondent mother and father were respondents in a proceeding brought under this chapter more than 182 days ago. Specifically, the disposition in initial case services plan adjudication was done by trial on 9/9/24, continued to 13th, and then the initial disposition took place October 7th, 2024. So certainly more than 6 months or 182 days, and that was as it relates to both parents. At that time, a case services plan was entered that outlined the abuse and neglect dynamics in the home, the domestic violence dynamics between the parents is articulated during the trial. found by the court during the trial. We had, of course, the psychiatric issues that mom was experiencing here, Ms. Walker. Finding her in the ditch, for example, officers, her admitting that she's hearing voices even during her psychological evaluation. Frankly, as recently as in the last report period to her counselor, one of the last times that she went to see her counselor. At that time, she was in and out of Mr. Hollis's home. They were not married. During the course of the period of time that the case has been open, they did get married. Mr. Hollis did not engage in case services in any real substantial way. Demonstrated some skills around interacting with his child during parenting time, during the trauma assessment. But he also demonstrated a really significant disconnect around understanding how his fight with Ms. Erica Hollis now, as well as his approach to parenting are detrimental to the child. So some examples of that are during the trauma assessment, the child demonstrated a fear of men. She had been, the family at the outset of the case was refusing to allow their daughter to be evaluated by early on, refusing to engage in some kind of Head Start programs or any kind of education or analysis of what her needs could be. She, at the time of removal, had significant physical limitations noted during the CTAC. Specifically, they were evaluated. She had some vision issues. She demonstrated food insecurity signs by shoveling food into her mouth, for example, hiding from people. She had some real indications that she had seen the domestic violence dynamics in the home and that had affected her. She had some delays that were being ignored. She was literally found the borderline risk in the areas of cognitive functioning, receptive functioning, fine and gross motor skills. So the parents showed some skills in bonding with the child, especially the father more than the mother. The bonding assessment with the mother was a really a more disconnected bond there, even at the time of the CTAC, which was put into evidence, I should say, at the time frame for the initial disposition back October 7th, 2024. So it had been done before that. You know, mom had described the child as bad, as a bully, who would deliberately do things, bad things, and laugh about it. The child was not really very interactive with her during that assessment. She would command the child to do some things, but really wasn't able to play with her, had a lot of trouble keeping up with her due to her physical limitations. And the child really didn't demonstrate that she wanted to go to her mother. She went to another person who was present there during the evaluation for comfort. And really the child refused to engage with her mom on the activities that took place during that trauma assessment. Dad's involvement indicated that he had decent interactions with the child, but he talked with her about things that had nothing to do with things that she would particularly be interested in, repairing cars and some other items and issues, and really didn't engage in any parenting time to demonstrate that he understood how to take care of her during or any regular caretaking skills for his child. At the time of the removal, Erica Hollis had taken the child, left the home. She was clearly in the middle of a psychotic episode. And Mr. Hollis had not even really reported that anything was going on. Wasn't reporting concerns about how that could affect his daughter. So I think in short, he'd like to hang out with her. And he certainly cares about his daughter, but as to understanding how his decisions to use substances and how to resolve conflict in the home were really affecting her. And his failure to understand or refusal to understand her basic needs and her developmental needs also significantly affected her. She has a litany of specialized services that she continues to engage in order to overcome some of those limitations as a result of the delay in attention on those areas. want to talk for a moment about the psychological evaluation and Harold's interview with Renee Moore. Both parents have some physical limitations, which is really just a minor issue as it relates to their interactions with the child, with the exception that it does contribute to their inability to keep her safe. She's a toddler, she's moving quickly. During the investigation into the home, it's only been very recently that the child's home environment potentially with the Hollises would have been even remotely safe. For a long time, for several review periods, I was hearing about how the child's room was stripped down to a subfloor, that the house was under construction, that it was not livable for a child or safe for a child at that time. They did remedy that. And in the meantime, the child is working on her developmental delays in the areas of fine motor skills, cognition, language, communication, emotional regulation, and coping skills. Harold, during his interview with Renee Moore, denied any domestic violence issues or any other issues, despite evidence at the outset of the case that he did have a drunk driving. And then, of course, I had ordered substance abuse services and an analysis. Because of that indication, during the course of the case, he did take some drug tests that did show up positive. So there was clearly an indication of substance issues there that arguably, if he resolved those, could have helped him resolve some of the domestic violence dynamics in the home, helped him develop some conflict resolution skills that didn't involve things like breaking windows in order to get back in the house, which happened just recently, or some of the other litany of phone calls that were tracked and received by the court during the course of time, interactions with neighbors that resulted in police calls, his interactions with his wife that resulted in police calls. I mean, these are not, it's sure every couple fights, but not every couple has fights that regularly require police involvement and attention to make sure that nothing significant is happening or no one needs to be arrested. And those are dynamics that clearly affect a child's ability to work on their skills, and did affect her here. And we have documentation of that. So the claim that really there's no harm, no foul here because of the way the parents interact and their substance use and their failure to look at their psychological issues, that really fails when you look at the proof that the court received over the period of time that this child was in care. She's still in many of those services to try to overcome the challenges that she faced while she was in the care of her parents. And she has made progress since then, which I will say has been great. So Mr. Hollis has clearly not made progress in the areas that he needed to around substance use, dynamics in the home, psychological interventions to try to reduce or eliminate the conflict in the home that has affected the child. He has not made progress in the area of understanding developmental needs of a child or how to take care of those needs or how to support the special needs of his child moving forward. And it's been nearly a year. 6 months is the time frame that the court is asked to look at by statute. It's been more than 6 months. She's a very young child. She needs safety and stability. So I cannot find that there's any reasonable likelihood that the conditions created by Mr. Hollis will be rectified within a reasonable time considering the child's age. And under subsection J, which is the other section that the court's been asked to look at, that there is a very much a reasonable likelihood based on his continued demonstrated conduct and lack of capacity in parenting that this child would be harmed if returned to the home of Mr. Hollis. We went through a lot of the details on that during the last report period, and I've highlighted many of those. The record really speaks for itself. The arguments have been made also very well by Ms. Thomas and Ms. Underwood during different review hearings. And I think I've hit on a couple of the things that really demonstrate that as recently as June. The police involvement in June. It was noted at our last hearing that he remains verbally aggressive and combative towards service providers when he disagrees with them. The drug screens were positive for methamphetamine and amphetamine, despite denial of use of those substances. He denies, he says that he's always been prepared for visits, that when the child was in his home with Ms. Hollis, he remarked that their relationship was great when she was there as to his daughter, which is really quite remarkable when you look at the petition for removal, which noted that Ms. Hollis was found in a ditch in a psychotic episode, and him not concerned about that piece at all. As it relates to the relative placement piece, I'll address that when we get back to the second aspect of the best interest factors findings. But he was very consistent during hearings, indicating that he's all dead to me as to the relative placement. He was very angry and upset when the child was placed with relatives, and blamed relatives as well as the department and the court for the removal. When he was asked why the child was removed, he said, quote, "Because my sister's an asshole, that's why," quote. He even became combative with his own attorney when going over the report. And I understand that this is a high stress situation, but these are just further demonstrations that the dynamics in the home that were identified at the outset of the case remain in full force and effect. Those dynamics very clearly affected this child, and she would be at significant risk of harm if returned to his care. As an extension of that, Ms. Hollis has decided that the best way forward for her is to marry Mr. Hollis during the court period of jurisdiction. So obviously that places, if her child were to be returned to her, that would place this child squarely in the home of Mr. Hollis, at risk of all of the indications that the courts just reviewed. Secondarily, she too has failed to benefit from services in any significant way during the period of time that the case has been open. There were some really serious, significant psychiatric issues happening for her. They continued over the period of time that the court's jurisdiction was open. She was hospitalized in December of 2024 for a potential suicide attempt, and this was one of, I think, 4 prior attempts, one of which was just a few months before that, as I recall, roughly. We, of course, had the continued domestic violence that was happening in the home, or the reports of domestic violence. We have police show up as recently as June 4th, 2025, wherein she was recognized as having a mark on her face, but denied that anything got more than physical or more than verbal, and didn't seem to have an issue or to think that it was an issue at all, that the verbal argument escalated to the point that she did sustain an injury, whether that was directly from Mr. Hollis or from the breaking window glass. Her remarks on her progress indicated that she is calmer now, which is great. She, for example, is not living in a car. She's not running away every 5 minutes or attacking Harold, which were all remarkable to the court. And also really are admissions of the kind of things that were clearly happening at some point in the past, which just goes to show that the dynamics in the home were not okay at the time that the child was removed, and that they were deviations from the norm to the extent that they were causing harm to the child. Let's see. She had not engaged in inpatient treatment, as Ms. Underwood noted. She had not engaged in outpatient treatment for AA or NA. She remarked when she was asked about the removal that, quote, "We didn't hurt her. She was going to her doctor's appointments. We were doing what we were supposed to do." Some of her other remarks included, "We didn't do anything wrong. Okay, I have a substance problem, but I can fix it." So these are, again, remarks that indicate that there's a real disconnect here in understanding how the dynamics in the home were directly affecting the child, how her failure to take care of her mental health were and the outgrowth of that, whether that's attacking Harold, hearing things that weren't there, or failing to notice when her daughter needed services, or taking her to those services. All of those things were affecting her child very significantly. And as recently as in the last couple of weeks, she still does not understand that that's affecting the child. The court finds certainly that that is a serious indication that there is no reasonable period of time, considering this child's age, that the conditions that led to the adjudication would be remedied. I also find that not only because of her continued residence with Mr. Hollis, but because of her own lack of progress, her continued intermittent at best treatment for her psychiatric issues. For example, she's discontinued from several different service providers. She's in and out of psychiatric care and counseling. We had the remark from Courtroom Family Services that those services were terminated because she was going to go for inpatient services around her addiction, which really is significant backsliding and discovery of how significant that identified issue really is and getting in the way potentially, or it was just another excuse because she really didn't think that there was anything wrong and didn't really think she needed to engage in learning about how to better parent a child. So for whatever those reasons are, she continues to have all of those struggles complicated by her use of methamphetamines. It's in significant disconnect in understanding her child's significant needs, or the gaps that were in place that led to those significant needs. So I do find there is clear and convincing evidence also to terminate her parental rights under C, I, and J. There's no question there will be a significant risk of harm if that child was returned to the care of her mother today. As I look at the best interest factors, one of the first things that we address is the child-parent bond, which I have spoken to. Again, I think that there's affection there. Harold Hollis's interactions with his daughter, to a limited extent, do demonstrate that affectionate bond. There was really no, frankly, to put it colloquially, there's really not a lot of love lost between Ms. Erica and her daughter, as was noted during the CTAC evaluation. She's pretty disconnected, which is very consistent, I think, with what's been noted on her psychiatric issues, where she's really just not there sometimes. And I'm sure that her daughter was very aware of that and was aware that trying to rely on her mom, who maybe wasn't even seeing or hearing things that were there, was not the best idea, and certainly undermined the parent-child bond in those circumstances. But the bond associated with the father and the child also was marked by, obviously, the dynamics of domestic violence in the home, which was demonstrated by her fear of men, and the insecurity around food and hiding from people do indicate that. And I would say, and Mr. Hollis being essentially the sole provider for Ms. Hollis as well as this child during that period of time, can only be characterized as part of his parent-child bond with his daughter. So yes, there's a bond there that has some highlights, but for the most part, it's characterized by a lot of very dangerous things that significantly limited her development and caused her a lot of challenges that she continues to try to overcome. She's a very young child. She has a significant need for stability and permanency, especially given her continued struggles in those cognitive delay areas. Now they're looking at whether or not she needs to be provided with asthma support. She's going in for that evaluation soon. She's still doing speech therapy as she heads into preschool and already has an IEP for those things. She's been working on overcoming some of those developmental delays over the course of several different review hearings. We've heard about her progress in the home where she is now, which is a stable, safe, relative environment. Both of the parents failed to take advantage of the relative placement in some of the traditional ways. They both felt that the relatives were part of the problem since they took in their daughter, since the relatives took in their daughter and really cut themselves off completely from any kind of interaction with the relatives. So they weren't able to enjoy some of those potentially extra contacts, like during family events or holidays or phone calls. So despite the relative placement, I do find that it's in the best interest of this child to terminate the parental rights of both parents. We had, of course, that supported by our LGAL and the caseworker. The child is too young to express a preference. There is a high likelihood of her being adopted into the home where she is now. She is bonded with that household, which has provided her the safe and stable environment that she needs moving forward, the medical care and development care to provide for her developmental needs. So there's a lot of reasons that Melanie has done, or the child, I should say, has done as well as she has. And those are attributed, unfortunately, not to the parents, but rather to the department's decision to ask the court to remove the child and to require attention to this child for the challenges that she had and needed to overcome as a result of her exposure to her parents in the home. So we will enter an order terminating the parental rights of Harold and Erica Hollis. There will be no further efforts towards reunification or to prevent removal. The child will be directed to at the adoption completely from this point forward, and we'll monitor the department's efforts on that as we move forward, and I'll issue orders to that effect. Both parents have the right to appeal. The orders will be provided to them if they choose to exercise that, including an attorney if they can't afford one on their own. I'll go ahead and set a review hearing after we're off the air, as from this point forward, essentially, we're going to be operating under the adoption code, which is confidential. Unless there's any questions, that's all for today.
Okay, folks. Let's go back to Miami-Dade. Let's see if he's made the ladies cry yet, because I think he was trying earlier. I need to step out of the studio for just a couple of minutes. Ashley, you're in charge.
I have a defendant here that we haven't called, Robert Hyland, Hyland. I'm told by our clerk that's on page 19.
He refused, Your Honor.
Okay, reset it for this afternoon. I have another defendant by the name of Carlton Davis.
He
I'm told by the clerk it's on page 20. He refused?
Yes.
Judge will waive his presence.
Thank you. Mr. Davis, on case F2518712, is charged with battery on by a detainee on a visitor or other detainee. I hereby find probable cause. I'll set the bond at $5,000. Then I have another defendant here. By the name of Eduardo Chavez.
He
Is
refused,
Mr.
Your Honor.
Refused?
Corrections, does he have a bond on the misdemeanor M25-13981?
I don't know.
I have it. He has a misdemeanor and 16218, it has $1,500. And on 13981, he has $5,000.
Corey, does it look like mutual combat to you?
Well, they both refused to cooperate, and I'm talking about Mr. Chavez, right?
Did you do $1, Judge?
I don't know. Let me give you a different perspective on these kind of cases. When an individual is incarcerated, it's inevitable they're going to get into a fight. But if there's no disincentive, then you have mob rules. You have in corrections, you have 40 inmates per corrections officer. So I respectfully disagree. I think the appropriate bond is $5,000.
Judge, can I give you my perspective?
Yes, ma'am.
So Judge, if you and I agree to a fight, that's mutual combat. That isn't, if we're in a boxing ring and we're like, okay, let's fight, and we duke it out, that's not a battery. That's a mutual combat, Judge. The fact that we might be in a jail is against the jail rules, and they'll have to be disciplined through the jail in their administrative procedures, which is a separate action, Judge. So with regard to mutual combat here, I would ask that you find no probable cause for battery because it's not an unlawful touching. It's a fight.
Well, how do you assume that this was an agreement to have a fight?
Because they both enter the cell and begin fighting, striking each other with their fists.
I think that's a good argument for a jury, but I'm not persuaded.
So,
I'm not persuaded.
and
I mean, like, if two people can agree to a duel, right, Ms. Corey? That doesn't make it legal, does it?
It could be charged with like a fray.
if you and I agree to a boxing match.
No, not a boxing match, a duel.
Well, this is what this is, Judge. This is a boxing match.
Were you there?
And that's what it says. They both got arrested, Judge.
Okay. Your request
If
is
they both
denied.
get arrested, then how can it be if it's
Your request is denied.
Would you at least lower the bond, Judge? Judge
No,
Glazer
ma'am.
has a standard bond of 2,500 for a real fight, not a mutual fight.
I'm not Judge Glazer.
$1,000 for mutual combat, Judge.
Okay,
We know
your
where-
request is denied again. All right, what about
I'm
Tizerius
sorry, Your Honor, what was
Jamadi
the-
Jackson?
Was the bond 5,000, Your Honor?
Yes, ma'am.
Thank you. He refused.
Your finding of probable cause is over defense objection for both cases, Mr.
Duly noted, and it's a strenuous objection.
Judge will waive his presence also.
PC is found, bond is set at $5,000. Okay, there's one case that I don't remember. Did we deal with the Christopher Carter case?
Yes, we did, Your Honor. It was 5,000.
Thank you so much. All right, do we have anything else that anybody wants to call up? Any criticisms? You're free, ladies, to make it now.
Already done.
So you are truculent. I do miss you in the courtroom, by the way.
I miss being in your courtroom too, Judge.
Yeah, well, listen, we had a great team in there, and I'm very blessed that there's still, great prosecutors and great.
Is Lisa still in there?
Yeah, actually, this doesn't have to be on the record, but I saw Lisa last night, and she's taken a couple of days off, and I've been working really hard to convince her not to retire, but I think I'm on the losing side of that argument.
When is her planned retirement? Did she?
She was gonna retire in December. I think she's gonna stick it out through December, but it's to be determined when she's definitely leaving. Listen, you were free to tell her this. Not only is she a great lawyer, I think she's one of the best lawyers I've seen, but on top of that, her judgment, her experience, and her mentorship of the attorneys in there is extraordinary.
Yeah, her mentorship is
No, she's a huge asset, and I'm not embarrassed to tell you that. I've told her, the public defender, that he should give her more money to keep her on, because I think, see, that's stuff you can't quantify sometimes, but the way she mentors everybody in there, including the prosecutors and
Right.
including the judge, a lot of times I'll ask her opinion on the record about a case, and there's no substitute for experience.
I agree, 100%.
But Seth, I also want you to say hello to your husband for me. I have fond memories of him, and I worked on a lot of cases from the defense side of the house, and I hope he's doing very well.
Yeah, Warren's good. So what time, Judge? 1:30?
Ask corrections, because they have more logistically to do than us. What's a good time? 1:30? 1:30. Corrections, is that good for you?
Yes, Your Honor.
All right. Listen, if anybody needs more time, just give us a call, give us a heads up, and just as a courtesy. And again, I want to thank our interpreter.
Thank you, Honor.
All right, we're in recess.
Eric, call corrections, please.
So a complete butthole on the record, but as soon as he gets off the record, he's an absolute sweet guy with a dog. He's got a dog with him. You gotta be kidding me. This guy is a mystery wrapped in an enigma. Wow. I'm okay. Happy Friday, everybody. Since I didn't say it earlier because we went right from the Lenawee rather county case into this. Thank you, Ashley, for 20 gifted memberships. Thank you, Bailey, for 10, and thank you, Grandma TCF, for 5. Very generous of all of you. I very much appreciate it, and congratulations to all the new members. Yeah, this guy's weird. I think I'm gonna try to capture the afternoon docket from here just to see if there's anything else interesting that goes on that we can watch later. 'Cause yeah, he's an animal guy. I'm so confused. All right, let's go to Michigan. Oh, Michael sends a membership. Thank you, Michael. Very much appreciated. Let's go to Michigan. Middleton is doing a bail arraignment, I guess. So let's see what's going on there.
Joshua Joseph Brown. Is that you, sir?
Yes, sir.
All right. This gentleman on the screen with us is Mr. Keith Stickley. He's the chief public defender for St. Joseph County. I've got 2 cases I need to see you on. The first one is 1755 SM. In that case, you're charged with 2 counts of assault and battery. And your lawyer is Luke Knopfsinger. You were set for a pretrial conference with your lawyer and you didn't show up. So I issued a bench warrant for your arrest. I came into work this morning and saw that you'd been arrested. So let's talk about that first case.
Good.
There it is. Well, I don't have both cases. But Peter gave me the felony case, but not the misdemeanor case. So let me find the misdemeanor case. No, I don't have it. Give me a minute. I'm gonna find it.
1755 if you don't have it.
I've got it, but I gotta go into custom queries. We're gonna get this case back on track. 24-1755. Is not in. It's always something. It's not in there under your name. It'd be easier if it was in my queue, but it isn't. So now I gotta look for it by file number. Under Joshua Brown, there is no 24-1755. So let me go by file number. I wonder why it's not in there. Because they've got it under Joseph Brown. Your name is Joshua Joseph Brown. All right, in that case, Mr. Brown, you were charged with 2 counts of assault and battery on Philip Warple, which occurred allegedly on September 16th of 2024. It's in there on the system incorrectly. I need to fix that. That room is so noisy. Anyway, I appointed a lawyer for you, Mr. Luke Knopfsinger. The prosecutor had offered a plea to there's 1 count of assault and battery. Well, we had a trial, you didn't show up. So I set the bond at $500 cash or surety with a 48-hour hold. I'm gonna reset the attorney pretrial for September 5th, which is next Friday. It's not a lot of notice, but you're in custody at 8:30. I think Mr. Knopfinger's set to be there that day. How did you come to get arrested last night?
I was at the house and state cop came over and said that I had a warrant.
Are you still at Congress Street?
I'm over here at Youngman Road and Golden Pond Trailer Park.
What lot number?
23.
Who are you living with?
Terry, hold on a second, I just woke up. There's a couple of my friends. It's Tara Lynch. And she get a boyfriend stays there too.
All right, well, so they came to that house and arrested you?
Yeah. I don't think they was actually looking for me at first to arrest me.
They came out there, ran your name and arrested him?
They arrested me, yeah. Over like a bike or something. Wanted me to pick up a bike or I don't know what it was about. But they ran my name and put me in jail. Yeah,
are you working someplace?
I was supposed to be starting, yeah. I was supposed to be starting on my golf ball. But they don't have it's hard getting in there because they don't have no receptionist. So I get called in and then there ain't nobody there to talk to.
All right, well, I'm gonna reset this for next Friday at 8:30. Bond is $500 cash or surety. You failed to appear before. We set a $2,000 bond, then I gave you a PR bond, then you failed to appear in November of 24, and then in December of 24. Also, you got several unpaid fines, and you owe me money in some cases, and you got a new charge, which we're gonna talk about in a minute. I wrote this on a different sheet. Yeah. You've got an unpaid fine in a trespass case, 232223.
We laugh because we care.
You got an unpaid fine of a retail fraud and filed 24910. You got an unpaid fine in an assault case. This is a bad one. Aggravated assault. It was part of a payment plan that I put you on last October. You charged with aggravated assault. I gave you 16 days jail credit, 16 days and a payment plan. You came up and set up a payment plan, and I don't believe you ever made a payment. So you have a payment plan on 3 cases with no payment. Those cases are 24910 OM. For 1448 SM.
I have people.
And 24232223. I'm not sure what the total is. $800. Anyway, you never made any payment. So I'm gonna set this one for a pretrial conference next Friday with your lawyer, Luke Knopfsinger. Did you ever talk to him?
Just that one time.
But then you didn't show up in court either in November or December, so I issued this warrant. So I'm not sure if you fell off the grid or what. Now, to further complicate things, you got a new case. Let's talk about that one. That one is in my queue. The magistrate would normally do this, but I'm here and I'll just do it. Try not to sneeze. In that case, you're charged in a formal complaint that alleges retail fraud in the first degree, that on or about April 22nd, you were at the Meyer store in Sturgis and you stole property worth more than $1,000. And they conspired with Christina Drake to steal that. So they charged her with retail fraud in the first degree and conspiracy to commit retail fraud. Those are felonies punishable by up to 5 years imprisonment and a fine of up to $10,000. You're also charged as a fourth habitual offender, making the maximum punishment for that up to life in prison. Now they're going to send you to life in prison for a retail fraud, but because it is a habitual, the maximum is up to life. File number is 25765FY. I need to get that case also on track. In this affidavit, they indicate that you left there with $1,081 worth of stuff. You had $1,081.21 worth of stuff in your cart. She had $972 worth of stuff. So the combined value was over $2,000 plus the value of the carts. They found actually her purse at any rate. There's video of this that they have from the store. So you fled. They didn't make an arrest at that point, and the prosecutor issued a warrant. And that was in April. And that warrant has been outstanding since April. I'm going to show a plea of not guilty. I'm going to appoint an attorney. I believe it will be Jordan Harden. I'm going to set a pre-exam conference for 9/9/25 at 8:30, and a preliminary examination if needed for 9/16/25 at 1 o'clock. Now, let's talk about this. You've been AWOL on my other case since December. While you're on bond and under a warrant, you were in the Meyer store allegedly in April on the 22nd. Now, they never caught up with you, so they never served the other warrant, ran away. Then you moved from Sturgis to rural Constantine or Three Rivers, and that's where you've been. They just happened to arrest you by happenstance. Now, you did have a Quaker Street address. Is that one, what was that one?
That was just a prior address that I lived at.
All right.
Sometimes
Did you?
I've been not trying to move around a lot, but when I was able to move back over to Golden Ponds over there, Youngman's, my children live out there, and the person I live with, they have a car, and they told me that if I can get a job, they can get me back and forth to work. So that's been working out really good. So it was kind of getting my life back together and getting everything back on track. And actually, I'm glad that this officer came and finally caught up with me, that maybe I can get all this stuff behind me now, because like I said, this probably they're trying to get a hold of me.
All right, hold on. All right, I'm gonna set a bond in that felony case. It's a fourth habitual offender. You were alleged to have a co-defendant, Christina Drake, and I'm not sure what happened to her. I didn't look her up. You've been AWOL on an assault case since November and December of last year. You never bothered to call your lawyer or make any arrangement to come in. While you're on that status, you got charged with this case as a fourth habitual offender. They only arrested you by happenstance. I'm going to set the bond in the amount of $2,500 cash or surety. The conditions are barred from Myers. I guess that's it. No weapons, no assaulting behavior, because you do have an assault and battery case and you have unpaid fines and costs and an aggravated assault. You were drunk, according to this, when they arrested you last night. Let's see what your blood alcohol was. And you're kind of sleeping it off here today. All right, you got a $500 cash or surety bond in the misdemeanor case, which I set back in December. The new case, I appointed a lawyer, Jordan Harden, and set a pre-exam conference for the 9th of September at 8:30 in the morning. Your bond in that case is $2,500 cash or surety. No weapons, no assaultive behavior. I'm going to order no alcohol as well. Are you likely to make that bond?
Probably not, sir.
All right. Well, as you said, the good news is at least we're going to address these issues. You've also got hundreds of dollars with unpaid fines and costs. So you've just been kind of staying under the radar. But $2,000 worth of theft from Myers is greater than the norm. I don't know what kind of stuff they allege you took. There's allegedly a videotape of it, and your lawyer can get a copy of that and view it with you. If you make bond, I want you to call your lawyer and make an appointment to discuss this with him. If you don't make your bond, she'll come out to the jail and see you. All right, sir, you're good to go.
Thank you.
All right. Good luck, sir.
Okay, we're going to pop over to Judge Elmore here in a minute, but a couple of housekeeping things. First, Monday is Labor Day, so officially we will not have a show that morning, but I reserve the right to pop in for an hour or two if stuff is going on, like Miami-Dade or El Paso, places like that, so we'll see. Also, Monday being the 1st of September, we won't be live to have you do this, but it is actually Grandma TCF's birthday. So if you could do me a favor in the chat and wish her a happy early birthday, that would be great. Let's go to a little further north in Michigan. We'll go to Judge Elmore. I've got no idea what he's got going on, but we'll find out together.
Are you ready, Nancy? Okay. Folks, good morning. We are on the record today here at the 28th Circuit Court for Wexford County. We are beginning today's docket call by taking up the case of People of the State of Michigan versus Brian Kelly. This is case number 25-14109FH. Appearances, please.
Nick Harns on behalf of the people.
Haven Etchomer on behalf of Mr. Kelly.
Thank you. And Mr. Kelly is here currently in pretrial custody, is now seated at the table next to his defense counsel. We are here today for an initial pretrial conference. The objective there is to see what's going on with the case. It's the first meeting before the circuit court after the case has been bound over and a scheduling order issued. I met with counsel in chambers, and they informed me that they anticipate a resolution with a pretrial agreement. Mr. Carnes?
Yes, Your Honor. People anticipate that defendant will enter a guilty plea to count 3 weapons, firearms, possession by prohibited person, as well as an added count of CSC 4th degree. The people will dismiss counts 1 and 2, both CSC and the 3rd degree, as well as the habitual offender's 2nd notice.
Thank you. Mr. Mayor, is that a correct and accurate statement?
Yes, Your Honor.
Thank you. Mr. Kelly, is that how you wish to resolve today's case?
Yes, Your Honor.
All right, you may remain seated, but please raise your right hand to the best that you can. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
Thank you. You may lower your hand. All right, Mr. Kelly, I say this most of the times, unless I forget. I like to remind people that they just took an oath. It's not a formality. Sometimes people treat it like a formality. I need to say to you today that everything you tell me has to be the truth. And because you raised your hand, I will assume that it is true. Why is that important? Because if you do enter a plea and I accept that plea, we won't do sentencing today. We'll come back in about a month from this coming Monday and do sentencing. And then at sentencing, sometimes the defendant starts to get cold feet. And then they try to backtrack and say, well, I didn't really mean that. I know I pled to it. Or can't do that because that's a different crime called, starts with a P.
Perjury.
Bingo. So I don't think you're going to. I've got no reason, but I just like to highlight that the most infamous types of cases are the people who plead guilty to meth in their pants, but then they say they weren't their pants. Anyways. All right. Now, by entering a plea today, you're not going to have a trial. Do you understand that? Great. Now, we're going to go over the charges here that are alleged, and then we're going to go over the terms of the pretrial agreement. You are currently charged on a felony information with 3 counts and what's called a sentencing enhancement. Count 1 and count 2 are both charges of criminal sexual conduct in the 3rd degree. Now, those involve an act of some kind of sexual penetration. And each of those are a felony punishable by up to 15 years, mandatory AIDS and STD testing, DNA taken upon arrest, and is a Tier 3 Sex Offender Registration Act offense that would require that you register, and that would be for a period of up to 25 years, if I recall correctly. Let me make sure I got that correct. I take that, bro. I take that back. Well, it depends upon the age. Nope, it is a lifetime registration. Thank you. There could also be a lifetime electronic monitoring based upon the age of the alleged victim. Now, those 2 counts also could be sentenced as a second habitual felony offender. So I told you that there was a sentencing enhancement. Now, a second habitual felony offender enhancement could increase that maximum punishment from up to 15 years to up to 22.5. However, both counts 1 and 2, as well as that second habitual enhancement, will be dismissed. Count 3 is a charge of weapons possession by a prohibited person. Generally, it means because you have a prior felony conviction. Now, that's a felony punishable by up to 5 years and or up to $5,000 plus mandatory forfeiture of the weapon or device. Now, because of the second habitual enhancement, that could have been increased up to 7.5 years and up to $7,500 in fines. However, if you plead guilty to that count, the prosecutor agrees to dismiss that sentencing enhancement, which means it will remain a felony punishable by up to 5 years and or up to $5,000. So far, is that what you understood?
Yes, Your Honor.
Now, there's an added count that I am told to which you are going to plead guilty. Now, that added count would be an added count 4. That would be an offense of criminal sexual conduct in the 4th degree. Criminal sexual conduct in the 4th degree would also require sex offender registration. However, instead of being a tier 3, it would be a tier 2 based upon the age of the alleged victim. A tier 2 registrant must register for a period of 25 years. And criminal sexual conduct in the 4th degree is a high court misdemeanor that is punishable by up to 2 years and or up to $2,000. And of course, because that second habitual enhancement will already be dismissed, there won't be any increase in that potential punishment. Do you understand?
Yes, Your Honor.
All right. Now, by entering a plea of guilty, you'll not have a trial of any kind. Does that make sense, Mr. Kelly?
Yes, Your Honor.
By entering a plea of guilty, if I accept that plea, we'll be waiving certain rights as they apply to this case. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you to appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at a trial if you chose to testify. Do you understand those rights?
Yes, Your Honor.
And again, most importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, Your Honor.
Additionally, any appeal that you might take would be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other threats, promises, or inducements to get you to plea that we haven't discussed?
No, Your Honor.
Are you making this plea today of your own free choice?
Yes, Your Honor.
Now, Ms. O'Mara, and I know it's covered for Mr. Harrison, they probably have talked to you about the Michigan sentencing guidelines and how they work and estimates and try to give you an idea as to what they think you might be sentenced to or what you might face. Has that happened?
Yes, Your Honor.
All right. Now, the key is there's a word that I use and it's called an estimate. I want you to understand that whatever they've told you is just merely an estimate. Has anybody told you or led you to believe what an exact sentence would be from this court?
No, Your Honor.
Okay. Now, when we talk about sentencing guidelines, those guidelines are issued by this legislature in Michigan. The intent is that they're to give the courts some parameters or suggested tools on how to establish a sentence. However, they are not mandatory. It is the court alone that will determine the sentence in accordance with Michigan law. Now that I've gone over the charges, what you're pleading to, your rights, potential sentencing, you still wish to enter the plea.
Yes, Your Honor.
As to count 3. All right, thank you. As to count 3, being a felon in possession of a firearm, how do you plead?
Guilty.
And as to added count 4, criminal sexual conduct in the 4th degree, how do you plead?
Guilty.
Now, before the court can accept your plea as to those 2 counts, I need to have you tell me what you did that makes you guilty of those 2 offenses. So turning your attention to July 12th of this year, 2025, up in the village of Niesick here in Wexford County. What happened? Let's talk about the CSC 4. Who was the other person? Hold on. I now see that the person's age. The person was between the ages of 13 and 16. Is that correct?
Correct, Your Honor.
And was this a male or a female?
Female, Your Honor.
And tell me I don't need you to tell me the name. What happened, or what did you do involving this female that would be criminal sexual conduct?
She showed up with another gentleman who was above the age of 18. They both lied about their ages and said that they were homeless. She told me that she felt like she was being used by him and didn't want to be with him no more. She wanted somebody more mature. And I told her I had no problem being that more mature gentleman. I was talking about being something younger, but I was open to the idea. And so we ended up going out and dating and having intercourse.
Now, did that intercourse take place up in Niesick?
Yes, it did, Your Honor.
Now, at the time, I'm just going to use this word in a general sense. Was it consensual or was it by force?
It was consensual, Your Honor. She actually came on to me.
Okay, thank you. Now we're going to go back and ask them, focus on the key question. At the time you engaged with that person, that woman, sexual intercourse, how old did you believe her to be?
18, Your Honor.
All right. And did she look 18, act 18?
She looked and acted like she was 18. She even said that her birthday was in the range of being 18 years old.
Okay.
And then I found out about 3 days later from a friend. He told me that she was 15, and that's when I called her.
Okay. So did you engage in any sexual intercourse with this young woman after you found out that she was under the age of 18?
No, yeah.
All right. All right. And you're the one that called the police?
Yes, Your Honor.
And did the police come out to the house?
With the mother, yes, Your Honor.
And so you told them this young woman's name?
Oh, yes, Your Honor.
And so they went and got the young woman?
Yes, Your Honor. With the mom, and the mom showed up and took her back home that night.
Okay. Well, now, Mr. Kelly, I'm going to make a statement right now, okay? And I don't want you to panic. I don't want you to feel bad, all right? You haven't done anything wrong. Remember, I talked to you about telling the truth. And you raised your hand, you took the oath. I talked to you right after that about how important it is and how I will interpret what you tell me to believe that you believe to be true. Okay. Well, there was no preliminary examination done in this case, so I can't look at something else and entertain a no contest plea. Granted, I could look at a police report, but right now the court cannot accept the plea as everything he has said is not a crime. Yes, sir?
Your Honor, there's no intent requirement for CSC 4.
But if he thought she was over 18, he said she was over 18, and he committed an act that he thought was lawful, you don't think there's a challengeable appeal?
No, Your Honor, I don't.
Okay.
I think there's case law on point. We can adjourn this.
Yeah, we're gonna have to adjourn this real quick. Now, hold on just a moment. Let me take a quick look here.
Your Honor, and
Yeah.
it's also my understanding that what consent does not constitute an excuse.
Does or does not?
Does not.
Well.
Or a defense.
I just want to, I'll look it up here. I still have a problem taking a plea. I mean, there's still, we're just gonna let that sit for a minute.
So while Judge is paging through his paperwork, just a reminder that even though it is a holiday weekend, tomorrow night we will have game night here at TCF, 8 p.m. Eastern, 5 p.m. Pacific. We're going to play the next level of Candleman. We're kind of rotating between Candleman and Lego Star Wars. So do join us, 8 p.m. Eastern, 5 p.m. Pacific. It's chill, it's fun. We're doing something other than court, and I hope to see you all there. Let's see if Judge has something to say yet. And no, he doesn't. So let's also call out the sponsor for today's show and for the channel as a whole right now, and that's Aura. I've talked about them 1,001 times, but do give them a look. Aura.com/TCF. There is a link in the description. You get 14 days for free. If you ever have any wonder as to what kind of information you have online, just try Googling yourself once. I did when Aura came to me, and the results were frightening. And then Aura showed me everything that was really out there, and that was even more frightening. And then they went to work for me, and everything's getting removed. A lot has been removed. They find more and remove that, and they've done a good job of protecting my identity. So let them help you too. Aura.com/TCF. You get 14 days for free. You have nothing to lose and everything to gain by giving it a try.
Your Honor, would you like a case?
All right, we're a few minutes in the Wayback Machine. I'm going to nudge this forward a little bit.
All right, man. Excuse me. I understand that there is, according to the People versus Cass decision from the Michigan Supreme Court back in 1984, that a reasonable mistake of age, there is no such defense, at least accepted then, and I don't see any reversing of that decision. I do see that there was some negative discussions about it in another case called People versus Perez. I guess I just have an issue with somebody who does, and based upon deception. It's a little bit different to me. Deception. The belief, one thing, but when you're actually lied to by another one. So I'll go ahead and proceed for now, and then if we come back, the court may entertain reviewing it again. All right, so Mr. Kelly, also, is it true that you had possessed some firearm on or about that day?
On the 26th, when the state police officers showed up to my house to conduct an investigation.
Where was that? What kind of firearm was it?
It was a 1908 single action black powder pistol that was sitting on top of my dog cage.
Okay. And so, I'm sorry, so it was in your possession. It wasn't somebody else's firearm.
No, it was mine. It was sitting inside my house on my dog cage.
Okay.
Apartment down.
And you knew at that time you had previously been convicted by, it looks like it was the 8th Circuit Court in Ionia County for a felony of flee and elude a police officer in the 4th degree.
Yes, Your Honor.
Thank you. Mr. Carnes, do you believe the defendant has provided a factual basis?
Yes, Your Honor.
So, Mary, do you agree?
Yes, Your Honor.
Mr. Carnes, are you aware of any of their promises, threats, or inducements?
No, Your Honor.
Ms. O'Mara, how about you?
No, Your Honor.
Mr. Carnes, do you believe the court is in compliance with the court rules 6.302?
Yes, Your Honor.
And Ms. O'Mara?
Yes, Your Honor.
All right, thank you. Court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements of the offenses. Therefore, the defendant is found guilty of count 3 and at count 4. Counts 1, 2, and the second habitual enhancement will be dismissed at the time of sentencing. Mr. Kelly, we will be back here in about 4 weeks for sentencing. At 5, we do them on Monday mornings. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. That report will contain information about the pretrial agreement, facts about the case, statements made by the victim, any statements or information you make or provide while in the preparation of this report. It will also include a scoring of the guidelines and a recommendation. It is merely a recommendation, as is the court alone that determines the sentence. Do you understand?
Yes, Your Honor.
There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet. The court has provided that to the bailiff. You will get it at the jail. You will complete it, turn it in. You have also will be subject to an interview with an agent from that office, and you have the right to have your attorney present during the time of that interview. Also, your counsel is going to have to meet with you and go over that report prior to coming back here to court for sentencing, because each side has the right to make objections or request corrections to the report before the court issues a sentence. Do you understand?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right. Make sure you complete as much of that as you can and make sure it's accurate. Anything further, Mr. Carnes?
No, Your Honor. Thank you.
Ms. O'Mara?
No, Your Honor.
Thank you. We're adjourned.
Okay, my friends, it is that time. It is Friday. It's time for this community's guilty pleasure, coming to you directly from a dank, dark basement room, poorly lit with lights powered by the souls of the damned, a carpet done in this special crimson red from The Shining, a grumpy judge who's not afraid to use the gavel. Ladies and gentlemen, I bring you Dungeon Court.
Victim here. The victim is available. She's an elderly lady who's disabled. It's his mother.
Okay, I remember that. Pamela Hash.
So, Your Honor, I've learned that on Wednesday, this past Wednesday, Mr. Sellers had a hearing about child support, and he was in contempt, and he received a 90-day jail sentence. However, I also understand that it can be reviewed well before the expiration of 90 days, but he does have some time to do. In the meantime, these are, if the court remembers, Ms. Hash's caretaker, her nurse was here last time and just expressed the terror they have over his behavior. And this is his mother, and the lady that takes care of his mother. He ought to be ashamed of himself, the way that he talks and acts around his mother who's not well. He deserves to be in jail. So we have these cases pending. If he wanted to go ahead and plead guilty today, we asked to look at sentencing maybe a week or 2 down the line. He's got to be in jail anyway. Maybe he could save himself a little bit of extra time if he comes clean on this stuff.
Your Honor, I just became aware of the case today. I haven't spoken to Mr. Sellers. I haven't seen any discovery. I'd like to send this back. Okay. And there's not a particular rush. He's got a 90-day jail sentence, so we could come back maybe 12 or 8. Actually, we're walking past the 15th.
15th is good.
Well, I'm actually not available on the 15th itself.
22nd?
I am available 22nd.
I gave him OR bonds previously, so, but it doesn't look like he's gonna get out anyway, so I'm not holding him in jail. Judge Sanders is. September 22nd will be the next hearing at 10 o'clock.
Thank you.
State of Ohio versus Laura Smith, case number CRA 25372, CRB 25373, and Jared Stover is on that.
And this is Mr. Shire's case also. Laura Smith.
We were here, can you hear us, Ms. Smith?
Yes, sir, I can hear.
Okay. We were here on Monday. At that time, we believed that Hometown Recovery was going to be able to take her. The person whose bed they were going to use ended up not graduating. The bed didn't come available. I was approached this morning by Southern Hope, who said they have a bed for her that actually open today. So I'd like to ask that we could maybe release her. I guess we would alter the entry to allow her to go to Southern Hope and then set it back relatively quickly, but doesn't need to be necessarily immediately, obviously.
Mr. Hill.
We're okay with that.
Okay, so I'm going to order that she be released and she can be picked up today by Southern Hope. Okay, she's ordered released to Southern Hope on a $2,000 OR and come back in a couple of weeks probably.
I'm not here the 15th, but I'm here the 12th or the 19th or the 22nd.
We'll be the 12th. September 12th will be the next hearing, be a preliminary hearing at 10 o'clock. So you're gonna get picked up today, you get her treatment, you gotta stay. If you don't stay, you got a felony, so you can run, go back to Huntington, but a felony warrant's good in every state in the union, so going to Huntington's not gonna do you any good. You'll just get arrested, go to Western Regional and sit for at least 3 weeks before you get to see a judge in circuit court, and then they'll just send you back over here. So stay and get clean. You're welcome.
State of Ohio versus Jared Stover, case number CRB 25521, CRB 25501, and CRB 25461.
This is Mr. Smith's case. Yeah, he's not there.
There it is. Mr. Stover, can you hear us?
Yes.
Okay, good. I had called down earlier, spoke to my client. I understand that one issue we had Monday was insurance. I understand that's how we've been reinstated. What we're going to take is schedule to post bonds, Mr. Showers. I would concur with that we would waive this hearing to the grand jury and ask the bond to transfer to common.
Yes.
Has there been a bond posted at this point?
His family, Gary said his family was posted. Mr. Stover, are you going to post the bond, Mr. Savage? Yes, Judge.
I'm waiting for the bond now.
What was that?
I'm waiting for the bond.
Waiting for Mr. Savage, so that sounds like that will be accomplished. His insurance has been reinstated, so that will be an issue with loss.
And there, initially, the requirement was there would be an ankle monitor.
Yes. I guess good luck with that on a 3-day weekend with being
Well,
Friday.
there had been one available, I'm not sure if it was.
There may be one, but I'll check.
Well, before we go further, I want to just say what, because I've been preparing for the hearings today, I looked at his files. Let's just lay the history out here. Case number 24674 in this court, April 2nd, 2024, he wrecked his car, tested 20 on a breath test for alcohol. That's 2.5 times the legal limit under Ohio law. He was convicted of physical control, February 21st, 25. Case number 24461, July 28th of 24, he was convicted or charged with assault of a victim, a female, convicted September 30th of 24. He incurred almost $9,000 in medical bills for injuries to her head and hand. Case number 25501, August 12th of this year, aggravated menacing charge that is still pending.
The last time we were in court, I asked for a $50,000 bond just because I knew the background. And we still believe that he's got some real bad issues that he's a threat to the public as long as he's out of jail. Now, I know there's been a long discussion about him going to treatment as well, and ankle monitors and the bond being posted and all that. And I also have Ramona Coleman here who says, you know, this is way overcharged, aggravated burglary is way overcharged. Well, I guess that's yet to be seen, but it's serious nonetheless. Our intention is for this case to go to the grand jury and for the response to this to get that appropriate treatment at that level. So our request is that if the court intends to allow him to be released to go to treatment, that there also be a waiver to the grand jury on this charge.
Yeah, absolutely. We discussed it. Yeah.
All right, and Ms. Coleman, do you want him ordered to stay away from you while this matter's pending?
No, I do not.
Okay. Now, the victim on the aggravated menacing is your son, correct?
Yes.
Is he an adult?
Yes. It was a verbal recording. It wasn't to, I mean, this wasn't to my son directly. And the incident on Sunday, it wasn't a situation of me telling him to stay away. He could have walked in the door is unlocked. It wasn't a thing of me telling him, do not come in my house, don't go away. He just came highly intoxicated and just kicked the door in. If I was afraid of him or anything, it wasn't that kind of situation. We are not a couple, but I have witnessed him in severe alcohol for a long time, and he has tried to get help, and he has been on several medications that are controlled substances from OVP, and that is when everything really went out of control in May of using alcohol with the prescription drugs.
Wait a minute, he got convicted of a crime of violence against another woman a year ago.
Right.
He put her in the hospital with injuries to her head and defensive injuries to her hand. $9,000. Were you aware of that?
Partially, yes, and I just found that in June.
So you're making excuses that don't fly. So,
I'm not saying
okay,
he's not
you don't
going to
need
be
to say
punished.
anything more. I'm going to do what's recommended here. Now, he's going to the Bluffs, is my understanding. Is that correct? So he'll be away from here. Now, there is a protection order to stay away from your son, and I don't see him here asking for that to be lifted. Is he here today?
No, sir.
So it's going to remain in effect. All right, so I'm going to require the $50,000 surety bond. I'm going to require a GPS monitor. I'm going to require that he not get around Kyle. And I'm going to require he stay in treatment. So it should be not a problem that I can't stop you from going to see him, but he's not to be out, he's gonna be in treatment. There's gonna be a waiver on 25/5/21 to the grand jury of the preliminary hearing. And the bond will be transferred down to common pleas. Now, the misdemeanor that is unrelated because it happened at a different time, so it's gonna stay here. What are we gonna do on that?
That one, I believe, is set for September the 19th.
That's correct.
And he, at the time, indicated he was going to hire an attorney.
Well, he's not working now, so I'll appoint Mr. Smith to represent him on that matter as well.
I'll reach out to him.
So we'll keep that same day.
Yeah, we'll keep that same, I'll reach out to him, we'll talk about that today.
And I think we have a representative from the boss here today. If he leaves, the court is to be immediately notified.
Definitely will. And is he getting released as today?
I'm sorry.
Is he really getting released
He has
as
to have a
today?
GPS monitor, so adult probation places those. Sometimes it doesn't happen the same day. So he'll be released when the bond's posted and the GPS monitor is placed on it. It could happen today.
He's gonna check out.
So, so we're gonna have a review hearing. He still has, no, I think that one's completed. So the only thing we'll have on the 19th is a pretrial on the menacing charge 25/501. Yeah, Mr. Sowers, you've been in touch with the parents, correct?
I have your, you said.
All right, next hearing, September the 19th. Mr. Stover, you need to take this seriously. Come out of here with a good report. Okay, good
Yes,
luck.
Your Honor. Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Charles Wallace, case number CRB 25/533A and B.
Excuse me, Your Honor.
Yes.
This is where we're cutting off a little bit. Now, what you said about the bond,
He's got a bond that's going to be posted with Mr. Sowers and an ankle monitor before he can be released. And he's going to be released to the treatment facility only, the Bluffs. He's only going to be released to the treatment facility. He's going to pick him up, from my understanding. The name of the treatment facility is the Bluffs, BLUFFS.
Okay, and how much was the bond say?
50,000, sure.
Yes. Awesome, sir, thank you, sir.
No problem.
State of Ohio versus Charles Wallace, case number CRB 25/533A and D, CRA 25/533A and B.
Sir, are you Charles Wallace?
Yes, sir.
All right, Mr. Wallace, let me go over your rights with you first. You have a right to remain silent. You don't have to say anything. What you do say is on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make a mistake, prove the charges beyond a reasonable doubt. Do you understand those things?
Yes.
Okay, you've got two charges, resisting arrest and disorderly conduct. So I'm going to go over those with you. 534A is the charge on resisting. It's alleged that in the village of Chesapeake, August 26th of this year, you resisted the lawful arrest of yourself. That is a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. 534B is disorderly conduct. Same time and place, it's alleged that you cause inconvenience, annoyance, alarm to others by engaging in fighting, threatening to do harm to other persons or their property, being violent or turbulent, and that you did this in the presence of a law enforcement officer. That's a 4th-degree misdemeanor disorderly conduct. The maximum penalty for that's 30 days in jail, $250 fine. And then there's another charge here, 25,533, A, B, and C. A alleges that on August 26, 2025, Village of Chesapeake, you did knowingly cause or try to cause physical harm to a law enforcement officer. So this charge is an felonious assault. Maximum penalty is 18 months in jail, $5,000 fine. 533B alleges that on the same time and place, Village of Chesapeake, you cause physical harm to property of the Ohio Department of Transportation being used by a year in jail, $2,500 fine. 533C alleges. Okay, the last charge is of vandalism. Maximum penalty is a year in jail, $2,500 fine. The next charge.
It keeps cutting in and out. I can't hear nothing wrong. You know, you can hear me right now. So,
I can hear you fine.
yeah, I couldn't hear hardly anything you say, but it just keeps cutting in and out. It sounds like an awful lot of charges that I can't hear what's going on.
Mr. Heald, if you could not type for a second, I think maybe he's picking up your.
Okay, sorry about that.
Okay, I'm going to go over the next set. You got assault on a police officer, that's a felony of 4th degree. Maximum penalty is 18 months in jail, $5,000 fine. You got vandalism, that's allegedly that you damaged property belonging to the Chesapeake Police Department. Maximum penalty is a year in jail, $2,500 fine. And this third charge is obstructing official business, that you prevented a public official in performance of their duties. Maximum penalty is a year in jail, $2,500 fine. Do you understand those charges?
I don't really understand all the charges.
Okay, well, do you have the money to hire a lawyer?
I'm probably going to have to, could I get an order of one bond? I also have $1,000 on me and a cell phone in my billfold, and so I didn't have nothing when I came here.
My question, Mr. Wallace, was do you have the money to hire a lawyer?
I don't.
Do you have a job?
I do have a job.
What do you do?
I have an apartment. I'm a bricklayer.
Do you work for someone?
I work for a couple people. Sean Parsons, he's a realtor. I work for Courtroom Masonry.
Are you paid by the hour?
Paid by the hour.
How much per hour?
15 an hour.
How many hours a week are you working?
I work 40 hours, usually, give or take, you know.
So you're making about $30,000 a year gross, is that right?
I mean, that's about what I'm making, you know.
Do you have any children you're supporting?
No.
You're a single person?
I'm single. I have an apartment I have to take care of in Chesapeake.
Okay, well, that's not one of the things I'm allowed to consider. I'm allowed to consider your gross income and what you have to spend to support dependents. So, what's the state's position on bond for Mr. Wallace?
Well, first of all, Your Honor, the South Point authorities did indicate to us that they confiscated $1,100, which they have holding for him, and they would ask for an order for that to be, I don't know what the proper word would be, but held because of the fact that there's going to be restitution for the damage to the vehicle. So we'd like an order that not be released at this time until the court can make a final decision on that. As far as the bond itself, we'd ask for a $25,000 cash surety bond.
All right, well, under that circumstance, then I'm going to appoint a lawyer. I probably should appoint Mr. Steyer. I'm appointing you a lawyer. I'm setting bond at 25,000 cash assured to cover both sets of files with the charges. You think you can post bond?
It would be about $2,500, sir.
No, I can't vote on.
Is this is there a salary in most cities?
Yes.
I'm here next Friday, and I have to have the preliminary set Friday in that case, so it's not just going to be on there.
All right, I'm going to set your next hearing for September the 5th, be preliminary hearings and pre-trials.
September the 25th?
No,
5th. Next Friday. I'm giving the files to your lawyer. You have a phone number if you get out on bond. You have a phone number where he can reach you?
Yeah.
You want to give it to him?
Just a second, we'll get that number here. Go ahead, please.
740-777-4340.
Thank you.
Thank you.
And is it, can we have an order for that $1,100?
Yeah, if you would draft something.
Mr. Stein?
Yes. Come on, the next case.
Tyler Young. State of Ohio versus Tyler Young, case number CRB 25509. Jeffrey Coster is on deck.
Mr. Stiers' case pre-trial.
Your Honor, it's my understanding that based on some issues that occurred at the jail, that Appalachian Behavioral Health was contacting the attempted pink slip, Mr. Young, but they said they didn't meet those criteria. With that in mind, I've got a concern that it may be appropriate to enter an obligatory insanity and/or a suggestion of competency. These are misdemeanors, so will there be anything around here?
That doesn't sound unreasonable to me, based on the fact that his own mother, who's the victim in this aggravated menacing charge, had actually sought and apparently obtained a mental hygiene warrant just about the same time that this happened.
But if I'm not mistaken, that was ordering him to go to ADH and then they wouldn't take him. Am I wrong about that?
I'm not sure, but it's probably possible.
Mr. Honor, I was informed by the Sheriff's Department today that
I am his mother, just so y'all know, I'm here today.
You want to come up and talk to the prosecutor?
Sure.
that ADH said that we did not meet the requirements.
Did they tell you they're waiting for a bed for him?
They had said that, but I guess he didn't get in. There is an underlying mental illness. There is. I don't have it, they won't give it to me. No. He was in North Carolina before.
See if there's a crisis. You know, it's run by Sean.
They were
Just, is there a jailer listening? I'm gonna assume from that being no. Do we know if it was the mental hygiene warrant that resulted in the situation at Appalachian, or if the jail itself asked the question?
What is it?
Was he referred to Appalachian Behavioral Health by the jail, or was that just already in motion when he came into the jail?
He was on a mental affidavit, and he got charged with whatever crime he was charged with, and Shawnee and Ashley Adams lived in.
So Shawnee did issue a pink slip, but Appalachian refused to take it.
I'm not sure if Appalachian refused to take it, yes, Shawnee did issue a pink slip.
And I don't, Your Honor, I think I have no choice but to file an NGRI and competency on this.
Would you also contact Shawnee and see, maybe investigate, because actually I remember doing the arraignment and telling him there had been a mental hygiene that he was going to go to the Appalachian Behavioral Hospital, and he seemed happy about it. He seemed like that would be a good, he wanted to get treatment. So it's very, again, disturbing we don't have more treatment options available.
An NGRI and competency have to be filed.
Does he have any medical providers that can deal with the issues that he's presenting?
And, not at this current moment, but I would be willing to take him somewhere.
Where do you guys live?
We live in South Point.
Okay.
Does he have a medical card?
A what?
A medical card?
No.
See, he's probably eligible though.
Just a second, sir. Just one moment, please. You don't have, he's not on private insurance, is he?
No, he's not.
Okay. He's probably qualified. That may be
I
something.
think he would be eligible for a Medicaid card.
Medicaid, so, okay, we
There's
can
a
apply for
place right
Medicaid.
here close to the court that does mental health counseling, TAF.
Okay,
They're down in the little shopping center, I believe, aren't they?
Yes.
okay,
Chesapeake Plaza Shopping Center,
okay,
where National City Bank used to be.
okay.
And you can walk in there, you know, take you.
They take walk-ins, okay.
Sir, I've given my phone number and my card to your mother. Sounds like, am I correct, that the state's gonna join the motion for no harm only?
We're okay with that. And then if ABH says that they want to take him, you have to make that decision too, whether that's a good idea, and it might be good for him. I don't know what.
Right.
I don't know.
Hey, it would be better if you didn't, sir, because you're on the record. I'm here to speak on your behalf. Yes, sir. We're working toward getting you out of jail. Once we got you out of jail, I'll be able to talk to you myself, and then figure out what we need to do as far as the court goes. I recognize that you're generally wanting to push things past the 15th. If we can get him out today, if we can maybe set this one for the 5th as well, I can meet with him, get in here, and maybe have some sort of a plan of action.
Yeah. It's gonna be another,
Okay, with this.
yeah. We're approaching 30 pre-trials.
I think there was a song about that.
All right, September the 5th will be the next hearing. He can be released on an OR bond of $2,000. Anything I need to order him to do or not do for your own protection while he's out of jail living with you?
Follow through with his mental health care.
Okay. And I'll say this too, if you're living in your mother's household and you're a grown man now, you gotta follow her rules. So if she tells you to do something, you gotta do it or get the heck out.
I will.
She gets to make the rules. Yeah.
So, sir, you're gonna get out. Your mom has my phone number. Give me a call, send me a text message. We're not gonna talk about the case by text message. If you can get a hold of me by text message, I can make arrangements to go speak to you by phone, and we'll figure this out.
So,
Okay, thank you so much, sir. I appreciate you. Thank you.
the next Friday will be his next hearing at 10 o'clock.
Okay. You can, do that along,
State of Ohio versus Jeffrey Costner.
All right, friends, it is time for us to call it a day and call it a week. And you could argue that's not a bad thing to call it a week because it's been quite the week. But nevertheless, it's always enjoyable to spend time with you guys. I've said it before. It's the reason why I get up before the sun rises every day. It's to spend time with you guys. And your generosity today was amazing. Thank you so much for that. And congratulations to all of our new channel members. Hope to see more and more people in the pre-show. Because that's where Dan lets his hair down, at least the 5 that he has left on the top of his head, and just kind of says, I just kind of say what's on my mind. So be sure to join us for that. We will be back tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific for game night. We'll play Candleman again. It has absolutely nothing to do with court, and that is the entire idea, is to just be able to gather up and chill a little bit. So tomorrow night, 8 p.m. Eastern, 5 Pacific. Officially, we will be back for the morning show on Tuesday, since Monday is Labor Day, and we'll be back Tuesday at the normal time, 10 a.m. East, 10 a.m. East, 7 Pacific, half an hour early for channel members. There's a possibility that I could go live Monday for an hour or two, depending on what might be going on out there. No guarantees, but you might see something pop up. In the meantime, please go have yourselves a good holiday weekend. Stay safe, have fun, cook some good food, spend some time with family and friends, and we'll see you soon. Take care. God bless.